Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 21-3057, United States of America versus Clark Calloway Jr. appellant. Ms. Taormina for the appellant, Ms. Kelly for the appellate.
Good morning, everybody.
Good morning.
Taormina, you can begin. And am I saying Taormina? I'm so sorry.
Absolutely. Good first try.
Great, thank you. I apologize.
No problem. May it please the court. Good morning. Rosanna Taormina from the Federal Public Defender's Office on behalf of Mr. Clark Calloway. I'd like to reserve 2 minutes for rebuttal. Mr. Calloway has raised 3 separate and independent arguments challenging the district court's use of Section 5K 2.14 to upwardly depart from the otherwise applicable sentencing guidelines range in this case. While each argument provides a standalone basis for remand, the court need not move beyond Mr. Calloway's very first argument with respect to factual impossibility, as it is the most simple and narrow basis for remand. The plain language of Section 5K 2.14 authorizes upward departure where national security, public health, or safety was significantly endangered by the defendant's offense. Here, the district court misinterpreted the guideline to include circumstances such as those in this case, where such endangerment was factually impossible because the weapon at issue was not in fact dangerous, but was rather an inoperable firearm put briefly into Mr. Calloway's possession before his immediate arrest as part of a carefully controlled government sting operation.
What if we take the disabled AK-47 out of the picture when we're trying to decide whether to do the upward departure? We would still have his possession of the machete, and we would still have all of the threats that he made on Facebook. What do we do with that?
Sure, Your Honor. First of all, it's important to note that this is a guidelines departure that's key to the offense and offense conduct. Offense is defined by the guidelines, and therefore his possession of the machete and the threats outside are more appropriately considered under 3553A than they are under the guidelines. They are not relevant conduct. They will be considered.
What do you make of the guidelines reference to nature and circumstances of the offense? Circumstances of the offense. In other words, I mean, if this were, Mother Teresa buying, a disabled gun, I'm not sure that we would have any reason for an upward departure unless she had made the threats that your client made and had kind of demonstrated the kind of, plan to use the weapons that your client made.
Yes, Your Honor, but Mother Teresa wouldn't be guilty of 924B in that circumstance. So looking at 924, looking at 924B, and I really do want to key what 924B says and what the offense is to determine what the circumstances of the offense would be. It specifically says whoever with intent to commit therewith an offense punishable by a felony would be guilty of this offense. So we're specifically talking about the firearm. This is a firearms offense. All of the other both the machete and I have a number of reasons why the machete shouldn't be considered and can't be considered alone. One of which is that the district court didn't consider it alone. It considered it in conjunction. So if the court were inclined to say, which I don't believe it can in light of the fact that this is a departure based on offense conduct, that we want to look past the gun, since the gun is one of the things that that the court specifically relied on. I would think there would have to be a remand to the district court to decide whether or not he would apply the departure without consideration of the gun. But in addition, so that's one thing. The offense conduct, again, is very specifically defined, and this is not offense conduct, the machete or the threats.
Sorry, I'm sorry.
Please, Your Honor.
Go ahead. Sorry, go ahead and finish.
I also want to say that that those things do not alone bear the weight of the language here. They still did not significantly endanger the public. If the machete were alone could shoulder the burden of this departure, then the government was derelict in allowing Mr. Calloway to remain at large in possession of a machete since 2016, which is when they first were aware of his possession. That's when he first started posting about his machete. The government didn't.
I apologize for the interruption, but I do want to ask about what you just said, because
Sure.
to me, the machete is quite important. And I'll kind of lay out this theory, and then you can tell me why I'm way off. But even if we agree with your argument that we don't look to kind of future threats, we just sort of look to the moment that the offense is taking place. One of the offenses was arranging to transport the gun across state lines. And so that offense took a little bit of time. And during that time, the facts on the ground are that your client seemed to have the motive and the means and the opportunity to commit a mass casualty event for hate crime reasons. He had pledged his fidelity to ISIS. He had called himself a mujahideen. He had repeatedly expressed a desire and intention to kill people based on their religion and based on their race. And then he was armed this whole time with a machete. And a machete can do quite a bit of damage, perhaps not as much as an AK-47, but over the course of about 3 months, machetes were responsible for about 500,000 deaths in Rwanda. They've been responsible for mass casualty events in Canada and the United States and South Korea. All these instances, 5 to 10 people were killed or injured at one time just with a machete, without a gun. So if he had the motive, means, and opportunity to commit a mass casualty event while he was arranging to transport the gun across state lines, why is that not textbook upward departure in terms of being a significant danger to public safety?
Your Honor, I would say that it would be a valid basis for an upward variance under 3553A. I think that the Third Circuit in the United States versus UCA discusses this, that the guidelines are keyed to the offense. And there's the Sentencing Commission chose specifically to, when they formulated the guidelines, to either key them to the offense or key them to broader conduct. And there's a long discussion about this in UCA. And so the guidelines, this is a guideline departure. This is that all of everything that you were talking about.
You keep saying it's tied to the offense, and I respect that, and I understand that, but the guideline refers to the nature and circumstances of the offense. And the circumstances here are that he had committed himself to a violent jihad. Do you agree that a violent jihad is a significant danger to public safety?
Your Honor, I would say that committing oneself to a violent jihad without acting upon it does not, in the words of the guideline, did not significantly endanger. The words are specific. They did not say could endanger the public safety. And I do now want to, I would like to move to how this guideline has been used in case law.
Wait a second.
Yes, Your Honor.
I would have thought you would have added that the district court here specifically rejected the argument that he was intending to engage in mass murder.
Yes, I apologize. 100%. That is, the court made very clear when the government repeatedly said that was what the court found. The court specifically interrupted the government and said, that is not what I found. He found only the intent to commit what the government charged. And that's another important point, is that the government did not charge intent to commit a mass casualty event, intent to commit murder, intent to a conspiracy and anything. What they charged was an intent to commit an ADW, assault with a deadly weapon, which is in the smack dab in the middle of the heartland of what a firearm could be used for. So that's.
Can I ask you a separate question, or maybe it's a predicate question?
Sure.
I'm just trying to understand. So your argument here, which turns on the factual impossibility of, because this gun had been affected in a way to make it inoperable. When you say that makes the 5K214 departure erroneous, are you arguing that as a matter of law, if the facts, whatever they are, but if there's just some factual consideration that means whatever the terrible threat, however horrible it was, couldn't in fact have happened, this guideline is unavailable?
Yes,
or are you arguing? I'm going to give you the three options.
Okay.
I think I can understand arguments. It fits into any box, and so I need your expert help. So one would be sort of a law argument like that. One would be application. So we understand what the guideline is, but how it was applied here on this record, this fact, including this. So is it an application error, law error, application error, or are you disputing the factual finding that there was ever, in fact, a threat to the public? Or to the safety?
I don't know that I would say I don't know that he made I don't know that it's a factual finding. I think that it is a legal conclusion with respect to.
I think it's a factual finding. I mean, the guideline calls for a factual finding that there was a threat, to a significant threat to safety. That's not a factual finding?
Well, first of all, I want to answer your question and make sure that we're talking about whether the actual words of the guideline, which was significantly endangered. And then, but I would say, Your Honor, that the answer is the first. I believe that this is a plain language interpretive issue, that the district court interpreted the guideline to allow for this type of conduct where it's factually impossible.
So this was so if we have a law error, so this was a sting operation, but imagine it wasn't a sting operation. It's just he's buying this AK-47. And it turns out there's, unbeknownst to both the seller and him, a manufacturing defect that renders it inoperable. But he buys it thinking it's fully functional, and the person sells it thinking it's fully functional. And as it turns out, the government's been watching the seller, and they happen to be waiting outside, and they grab him before he can take any further steps. So in that situation, you would have the same position.
I would, Your Honor, and that's where I do want to go to the case law here, because what you're seeing is.
What if, instead, I want to test how the rule of law works. What if instead of the firearm being inoperable, the defendant had say a sort of a hand disability or something that was going to make, he didn't know. He thought he could operate an AK-47, but for some reason he lacks the physical ability to do so, to pull the trigger because of nerve damage in his hands or something, but doesn't know that. So the firearm is fully operable, but as it turns out, he's not factually capable of operating the firearm.
Your Honor, I think that still would not qualify here, but it would not leave the district.
Even if he's walking out on the street now with this AK-47, lifts it up and then tries to pull the trigger and can't.
Well, right, but yes, I don't think that qualifies here under this guideline. But to be very clear, Your Honor, that is something that I'm not saying that the court couldn't consider his culpability and his intent in in the 3553A factors, that analysis includes the history and characteristics of the
Which
defendant.
raises another question for me, because if I recall correctly, the district court here said, and even, without these guideline factors, applying 3553 factors, I would give you this same sentence.
He did not say that, Your Honor. In fact, it's something that we always look for as in our office to make sure that whether or not the court said that, and he didn't. He actually said that I think a guideline sentence is appropriate in this case, which to me shows that
The city was rejecting a higher or lower sentence based on 3553 factors, 53A factors.
Right, but which means that he keyed his sentence to his guideline calculation, which he included the departure. This court is.
But he also says, given 3553 factors, I don't think anything higher or lower is warranted. Isn't that?
He didn't think that the variance arguments were warranted an upward or
I know, but no, I think in saying that, maybe I'm doing too much mind reading here, and that's my error. It seems to me a statement, at bottom, that the 3553A factors leave me where I am. I'm not they don't warrant something higher. They don't warrant something lower, which in some Goldilocks way makes it sound like this is in fact the 3553 sentence. I think,
and this court in particular and district courts in general are know that in these circumstances, and in fact, this court earlier in the proceeding specifically said to the government, why are you doing this way? You're opening yourself up to appeal by asking for these departures. And so the court understood, and courts understand, that they very specifically say whether or not this particular guideline applied. And when he was doing the 3553A factors, that was after he had already written his decision on the departures, and he was looking within that guideline range based on the variance arguments that the counselor was making that day to decide whether to go up or down. Mm-hmm. And had he had a different baseline by not applying this 2-point departure, we don't know what his analysis would be. And that is going to be a question on remand if there's a remand in this case. Okay. He can use 3553, but he did not make clear that with respect to
he could use 3553 to reimpose this exact same sentence.
Yes, but he did not make clear on the record that with or without this particular departure, he would give the same sentence. And that's what courts need to be clear in saying. Because I do agree with you that if he had said that this would not be a basis for appeal for us. If he had said,
I appreciate that. And just one more thing to understand your rule of law argument. Does it ever change based on the nature of what's being acquired? Say instead of a AK-47, he was obtaining a nuclear bomb. And understandably, they hand over a disabled nuclear bomb. Thankfully, we would want that. A court could not find that his attempted acquisition, and we'll have the same record of online statements, just trying to get something like this in combination with those statements creates a threat to public safety.
With this particular departure, Your Honor, I would say that it does not qualify under this departure, but please understand that I'm not saying that a court could not consider that information when sentencing and when with respect to the whole picture in 3553A. But this departure is specifically, is trying to have to punish someone differently for the person who's sitting in their house wanting to do something bad, and then the person who leaves their house and does something bad. There has to be a difference there, and that's what this.
And he left his house to buy this. this weapon. But I guess if what you're saying is this sentence could be a perfectly reasonable sentence if the district court had just packed it into 3553. What is the point of this claim then? Because, you know, it's a departure, but that's because it was written before the guidelines became entirely advisory.
Right.
You don't really have departures at this point. It's all advisory. And so why isn't what he did there effectively a 3553A analysis? We don't require them to label that, but because you don't have to justify departures like you would have pre-Booker, he was going through these facts and he was applying, as he sort of said at the end of the day, when I look at these 3553A factors, I'm left right where I started on this same sentence. And so it almost seems to me that there's a...
Your Honor, I think that
it's said it would be reasonable to impose this same sentence under 35.
Yes, I don't believe that we would have a substantively unreasonable argument there. But I think it's important to compare this situation, even though this is an upward departure, to a situation where the court incorrectly calculates the guidelines. And the Supreme Court has said that even in those circumstances that is considered plain error, and that a defendant is entitled to resentencing, even if the sentence would otherwise be considered reasonable when there is a guidelines calculation error. And the court in this case treated this departure as essentially a guidelines, as an enhancement, as a guidelines, as just a part of its guidelines calculation. And in fact, it actually when it gave its departure guideline range, it told the defendant that the courts will automatically, any sentence within this range will be considered reasonable by the Court of Appeals because it's within the guideline range. So, but that's an incorrect statement of law, because it's the guideline range is a pre-departure guideline range. So only the pre-departure guideline range is considered reasonable by the court, which is only to say that the court clearly treated this departure as if it were a part of its guidelines calculation, and had it not calculated the guidelines in this manner, we do not know where the court, or how much the court would have varied, where the court would have, whether it would have varied, where the court would have come out here, because this essentially put an idea in the court's mind that this was an appropriate reason to depart upward. And again, by in this instance, two levels. When courts vary, they generally don't vary in that manner. They'll go up a few months from the high end of the guideline range, or we just don't know how the court would have handled this situation.
All right, can I
not treat it?
Just one more sentence.
Yes,
how if at all does intent factor into the 5K 214 analysis of whether someone posed or whether there was a significant threat to safety? Your Honor, as I said, I'm sorry.
Here, it doesn't factor into the factual impossibility argument. So because that's key to whether or not it was possible, no matter someone's intent. But I do believe that the case law, the great weight of the case law shows that it is this departure is given when people go out and do the harm that 5K 2.14 is aimed at. Well, I'm trying to understand with that. So if we don't look, if factual impossibility is sort of a bright line that can't be crossed, and intent can't change that, then you're asking this court to say that no matter how strong the record of intent, and no matter how much pre-planning, pre-staged, ready to go conduct there is for the most horrific actions that there could be, if it turns out that there is just this whether even if it's flukish reason for why it can't actually happen, this guideline can't apply. I'm just trying, and that may well be correct. I'm just trying to make sure I'm thinking through
consequences on both ends here.
You are, but Your Honor, I don't think that the court needs to be afraid of like this does not really tie the hands of a court in taking that into consideration under 3553. It would change I think that it will change the analysis in this case because of the way the court calculated the guidelines, analyzed the issue. But please understand that there's
Can I ask you
no
about,
argument. Sure.
please take Judge Millett's hypothetical that she just asked,
Yes.
except change the very end of it. In Judge Millett's hypothetical, there was some reason that we can feel certain that the terrible plan, it was impossible that it would happen. It's like a fluke. But imagine instead that it's just as simple as the police caught him before he did it. So same, all the planning, all the terrible stuff. And then the only reason it doesn't happen is that the police catch him, before he does it. In that instance, could there be an upward departure under this guideline?
In that instance, I mean, first of all, that's not this case. So I would encourage the court to
I know.
really be very narrow.
You're asking for a rule of law.
I think that's, but I think that, and I do think, and that's why I think the government's brief is so long, because like everything else is very interesting to talk about. It is difficult to line draw. I do concede.
You've been so responsive to all of our questions so far, and I'm grateful for that. But here, I really do want an answer to this question as well.
So if the police stopped him before he endangered public safety, then I would say that it doesn't apply. But please, Your Honor, understand that.
No, but you mean you're kind of baking in the answer to the hypothetical. You're saying if he stopped him before he endangers public safety. I'm saying he makes a terrible plan. He has every intent to do it. He has the means to do it. And the police catch him just before he's going to, let's say, commit a mass casualty event. In that situation, could there be an upward departure under this guideline?
I think that I can't think of a similar case where the guideline has been applied in this. So I would say no. Okay. I would say no, Your Honor. And I would say that does not.
You can do it under 3553A.
Yes, please. Like I think it's really important to know that I'm not saying that this is not allowed.
Okay, please let me. I'm going to ask one more question. This is somewhat different tack. We had a case this court did about a year ago. It was an enhancement for a child sex predator. The enhancement applied if the victim was 14 years or younger. And the defendant's argument was, well, that should not apply because here it was a sting operation. There was no actual child involved. It was an FBI agent on the other end of the conversation with the defendant. And this court said, well, the enhancement still does apply because even though there was not literally a child 14 or under involved in this crime, the defendant, basically acted as if there was. That seems quite analogous to this case where, here's my question. If there didn't have to be a real child in order to get the enhancement for a child, why does there have to be an enabled gun in order to get the enhancement for a gun?
Because I think that the guideline with respect to the age of the child, and I have not studied that particular guideline and the Sentencing Commission's reasons for that enhancement, but it could very well be tied more to the culpability of the defendant than it is to the harm to a child. And if it's not tied to the harm to a child and there is no existing child, then that makes sense. the distinction here is that the way that this guideline, and again, it's a policy statement, it's a departure guideline, is written, is it says that the public safety was significantly endangered. So it's very clear that the Sentencing Commission was less involved in interested in culpability than it is in the actual effect of the defendant's conduct. So that's how I would distinguish those two cases.
Thank you for your patience.
Colleagues don't have any more questions. We kept you up a little bit longer than planned. Thank you very much, Ms. Termina.
Thank you.
Government. And we'll give you some time for rebuttal.
Morning, Your Honors. May it please the court. Catherine Kelly on behalf of the United States. Your Honors, in this case, the district court appropriately applied guideline 5K 2.14 as a departure in this case. It was not undercut by the fact that the FBI had very reasonably disabled the AK-47 and immediately arrested him after turning it over. Defense argument really forecloses the idea that you can apply this guideline departure at all anytime the FBI does its job, whether it turns over through a cooperator a disabled firearm or whether or not it turns over a fake nuclear weapon, as Your Honor had mentioned in your hypothetical.
I know, but I mean, the government position here also sort of wants to blink reality, right? And what are the limits on that? What is it that makes him, since it wasn't the gun in reality that made him in danger, or that endangered safety? What was it? Was it his intent?
It's his intent. It's his repeated statements, not only in particular during the time that he's actually taking part in this offense, the offense of interstate transport or causing the interstate transport of the AK-47 and ammunition. He's repeatedly telling people on Facebook and cooperators what he plans to do with this gun. And not only just the gun, he has the machete as well. Just a couple of weeks before this gun is turned over, he is on Facebook saying that he got AK-47 en route, machete on deck, that he is ready to kill anyone who isn't a Muslim in these final days. That was one of his main statements during that period of time. Even after he was arrested when he was in CTF.
The government didn't think that was arrestable conduct. That conduct itself, even with this machete sitting there in his apartment, was something that posed even enough of a threat to warrant arrest in its own right.
It's not clear to me, Your Honor, and I have not looked deeply
Was that,
into this.
could he have been arrested at that point without the AK-47
I don't
purchase?
know that possession of a machete is a federal offense. I haven't looked into that, but I don't know of any law off the top of my head that indicates that just mere possession of a machete is a federal offense.
Oh, so the state or?
That's a possibility. I mean, the FBI could have tipped off.
That would be, you're ranting, let's say ranting on Facebook while lawfully armed. We'll assume that for the machete.
Mhm.
People can get jailed for that. I think the jails will be very full.
I don't think that just ranting about it with possessing a machete in your apartment would get you.
So what was more than ranting here?
More than ranting here is that he was trying to get this cooperator CS3 to sell him an AK-47 and ammunition.
So it really is the AK-47.
That is the main
That's what
part
he
of it.
thought was going to be able to allow him to cause assault with to undertake assault with a deadly weapon, even though he already had a deadly weapon that he could assault with.
That was what was charged in count one, interstate
That's
transport.
what the district court found here too, for the basis for the enhancement, was intent to commit assault with a deadly weapon, not mass murder. He didn't find that.
That's correct, Your Honor.
Okay, so it was transporting, even though he already had expressed these views and had a deadly weapon at hand, it was arranging for the AK-47 that suddenly made him a threat to safety, because then he would commit an assault with a deadly weapon.
That was just the charged offense in count one was the interstate
Not what I'm
transport.
asking. That's the finding that the district court relied upon here to apply this enhancement. was that he was going to commit assault with a deadly weapon based on, in fact, the district court said he's got the machete, but he had the machete and he had the online language before anything was involved with the AK-47. And I thought you just said you didn't think there'd be any federal offense there. It wouldn't be a federal assault with a deadly weapon. So I'm just assuming here the machete at some point crossed state lines. It was purchased from a store or something. It was purchased somewhere. He didn't hand make it. So you have you have a deadly weapon and his threats of assault. And if that's really what the government thought the risk that was, then we don't need the AK-47 at all.
I'm not sure that the government had any information as to when he obtained the machete. He had had the machete for a number of years, according to his Facebook post. So it's not.
So they knew for a complete number of years that he had a machete and was making these assaults. And so then there's this sort of, it sounds more loaded than I mean it, manufactured, but the structured transport and purchase that's entirely a government controlled operation. There's never any, if we think the risk before, based on his machete and his threats and his language, his horrible language, vile language, made him a threat to commit assault with a deadly weapon. And let's say it's a 80% chance, and we'll call that enough to be, significant endangerment. That 80% didn't change. Ever changed because it was the government transporting, government controlling, government disabled. The percentage never changed. Right? Nothing changed with respect to the AK-47 situation vis-a-vis the threat to the public or to the officers or to anybody. No one's safety was changed by that. Or tell me how it was.
Well, other than the fact that it's much easier to kill far more people very quickly without getting yourself in a hand-to-hand combat.
Not with a disabled. No.
Not with the disabled. The fact
He'd be better off with a machete.
The fact that it was disabled is just one factor to be looked at in this.
No, I'm asking you, it may be the factor that's at issue in this. It is the factor that the defense is raising here. And it seems a really important one because on the one hand, the government wants to say, this was it. This AK-47 is what made him, in combination with pre-existing factors, but those alone weren't enough. This was the moment that it all changed. When we know, in fact, that with respect to the threat to public safety, nothing changed. There was no actual factual change in the threat to public safety.
He did not have an currently operable AK-47 at that moment. Yes, we certainly concede that, but
was there a currently operable one that he caused to move in interstate commerce?
Not that was currently operable.
Okay, so not that moment and not any moment before. So just help me understand how the threat to safety, public safety, officer safety changed at all from what it was before. There was this baseline before with machete and the threats. How did it, in fact, change?
That gun could have been made operable had he been allowed to hold on to it.
That was never going to happen. That was never going to happen.
It's still nonetheless a machine gun.
Zero chance of that happening. Was there any percentile chance that he was going to be able to get away, get out of the room, take it somewhere?
There's always some possibility that he could have escaped the apartment and made it operable. He had 4 years of serious Marine training.
Okay, where is that finding by the district court?
It was a fact that was discussed in numerous points. I don't think the court put in.
The court made no such finding.
No, the court didn't make a finding about.
That wasn't any part of the district court's factual basis for imposing this enhancement. Correct?
His military training or his ability to.
That he might somehow escape
and
get all the way to wherever it is he needs to go and get the equipment to make this operable.
That was not part of the court.
So what is it that the district court pointed to that took this threat to safety from that pre-existing level that wasn't enough? What was it?
I don't believe that it's the pre-existing level was not enough. The court did rely extensively on
He never
Mr.
said that was enough by itself.
He was
He
saying that
never
was,
said that was enough by itself.
did not say it was enough by itself. He was combining
Okay,
the
so
nature.
we couldn't make that decision either. You maybe could argue it on remand, but I mean, this is the difficulty of this case. It's not just a factor, is that we're supposed to find that the offense conduct, which was the acquisition of this AK-47 with the intent to commit an assault with a deadly weapon, not a mass killing. We're supposed to find that that is what so qualitatively changed the threat that he posed to safety as to warrant a significant threat to safety, as to warrant this departure. And it's just hard for me to get my mind about it if there was nothing. And it's not, we can't even sort of do the nuclear weapon, it's the nature of what he was acquiring, because in some parts of this country, AK-47s are lawful weapons for people to possess.
That doesn't make them any less
knowing
lethal.
it's possess a nuclear weapon, right?
An AK-47 is still a highly lethal weapon. I mean, it's not a matter of something where you're just getting a starter.
So are they're all guns by definition lethal, but that's not the point here, because he did not. He happened to acquire one that was not lethal.
Well, then that's creating a bright line rule that
Yes,
anytime the
but
FBI does its job, then you can never say that somebody has been in a situation where you're significantly endangering.
We
Well,
don't,
you're begs the question when this can be used.
excuse me, we don't want the police to create sting operations that in that own conduct significantly threaten safety. We wouldn't want that. It seems backwards to say that we want to say what the government did here significantly or created a significant threat to safety. But no one would ever want to say that outdoors in the real world. The police are quite careful and conscientious not to, both for the public safety and presumably and hopefully for their own. It seems like we're like where I started, blinking reality here.
I don't think
What do I do with that?
I don't think we are blinking reality. For the couple of cases that we pointed out in our brief, the Roth case and the Todd case are situations where the district court applied this guidelines departure in situations that could have endangered national security. In the Roth case in particular, the FBI was involved.
What it takes to endanger national security can be very different from what it takes to just the morale issues with the military, theft of military equipment can be a problem. That's not what we're talking about here.
My
We're talking
understanding
about the argument here is that it was this AK-47's purchase that changed everything because of he was acquiring this weapon.
and it's not
No
just,
other arguments.
it's not just the purchase, is what he was saying he was going to do with the gun all along. And even when he was in CTF, he was telling W7 what he had planned to do. He was disappointed that he was shut down so quickly because his goal had been, as he was saying, to buy
I
multiple.
understand that what he said, I get that. I've stipulated, we have that and we have the machete beforehand. What I'm struggling with is, in fact, in reality, his ability to undertake that harm did not change for a second.
Only because the FBI did its job.
Of course, we stop that. That begs the very question here. Because the FBI did its job, absolutely, the FBI did its job to keep the public safe, to engage in its difficult investigatory measures in a way that still protects public safety. So when you say only because the FBI did its job, let's substitute in only because public safety was preserved and unaffected. That's what you mean by that.
It's a situation too where we also have a defendant who was not trying to buy a disabled. He fully believed that he was not trying to buy a disabled firearm. He fully believed that he was buying a gun that was capable of firing.
Intent?
His intent is very important here.
is his intent alone what changes it to a public safety risk?
I think his intent is very, very important.
No,
factor here.
I'm gonna ask again.
Is the
Could
intent.
we write an opinion that says his intent alone? Exactly. His intent alone, which he had all along with machete hanging in his apartment. His intent alone changed it.
I think you could, because based on his statements.
district court
he's
didn't do
telling you. No, but the district court did rely very heavily on his statements
Yes.
and what his plans were. And
But they didn't
stated it.
So if he were, he had the intent, was also someone who was really, really, and this is hypothetical, to be clear, really, really stupid and confused. So not someone with military background, and thought if I just had a sharp pair of scissors, I could kill many, many people. I could kill the police officers or the non-Muslims. And that is my intent. And I'm going to acquire a sharp pair of scissors. And the FBI hands him kindergarten dull scissors. Has the threat to public safety changed because of his intent? He thinks he's got it now, but actually it's those dull scissors that can't hurt anybody.
I don't think so in that situation, because of course the sharp pair of
What's the
scissors
difference
is
between dull
so
scissors
different.
and a dull/disabled gun?
The disabled gun can be made operable and it could easily kill many, many people, particularly when it's been turned over
You
with
can
live
sharpen metal. You
ammunition.
can sharpen metal. You can sharpen those scissors.
Again, that's something that takes an awful lot of hand-to-hand combat with somebody, as opposed to just walking into a police station like he intended and
I'm
mowing
sorry,
down
he can't
police
do that.
officers.
Okay, so I know you want to keep making that argument, which the district court rejected. I would like to rely on what the district court found here, these arguments. And he didn't even agree to that in his plea. He didn't have any recollection of this thing about police stations.
The government, that was
couldn't
cleared
go
up.
walking anywhere with that AK-47.
I just want to make clear that he did not recall at the time of his plea, his belief at that time was that he didn't make that statement. The defense counsel later agreed that he did make that statement. It was included in the statements that he had made to cooperators and Facebook and on Facebook. I can't remember if it was a statement to CS3 or
Did
what.
the district court find it?
The district court had asked after the plea what statements should be considered, in particular since he had made the statement at the plea that he didn't recall saying he did anything about going into a police station. But defense counsel later agreed, it's page A230 of the record, that agreed to the accuracy of the defendant's Facebook posts and his statements attributed to him when he was being secretly recorded by the confidential.
And even that, but the district court just said, I'm not relying on that. All the district court said was he intended to commit assault with a deadly weapon.
And that's what was charged. The district court said that it was the government's.
It was charged. You had to have an offense for purposes,
The felony,
offense for 924.
Yes.
But the district court also pointed to, and only to, his intent to use the AK-47 to commit assault with a deadly weapon as the basis for the enhancement.
That's correct, but you can certainly assault more than one
Which would
person
seem,
with a deadly weapon. The only thing the district court was really saying.
the district court, and you did, saying it's for our purposes, we rely on what the district court.
Right. But the district court certainly did not say that it was finding that multiple people would not be killed in this situation.
How would,
It was just saying the government's gloss on the facts was giving, and it's not a gloss out of nowhere. It's based on what his statements are, that he wants to kill white people. He wants to kill police officers. He wants to kill anybody who is a Muslim. So we're not talking
no one's
about,
disputing those statements,
right.
which are all made with.
All of that supports that it's not just an ADW where you go and you find one person and you point the gun at them. He is saying, I want to kill, and I want to kill people, large number, a whole variety.
I don't read the district court opinion maybe the same way that you do. I mean, I understand those arguments were there and those statements were there, and they're terrible statements. And they were made at the time he had a machete, which Judge Walker has pointed out itself could have been used all along to commit many people, to injure or kill multiple people. So I'm trying to, again, focus, as the guideline requires us, on that, the offense at issue here, the 924C acquisition, and how that changed anything. But I've monopolized your time too much. Can I ask you one thing, though? He has been released, right? He's no longer in prison?
He's on supervised release as of April 21st.
Okay. But there's no mootness argument because this could affect supervised release?
Exactly, Your Honor.
Well, let me read this sentence, and I guess my question is this should we treat this as a factual finding? Should we treat this as a legal conclusion? What do we do with this sentence?
I believe it is a factual finding.
No, I haven't told you the sentence yet.
Sorry, Your Honor.
I just haven't told you the sentence yet.
Oh, I'm sorry.
This is on JA 296.
And I'm sorry, which statement on J?
So it's in the middle of the page. It says the dangerous nature of the defendant at the time of the offense, being armed with multiple weapons that he intended to use in carrying out an attack, created a serious risk that multiple individuals could have been killed or injured. Should we think of that as not a factual finding? Should we think, what?
I believe it's a factual finding, and if it was any more than a factual finding, what the court is doing is applying the facts to
You said
the
repeatedly
guideline.
in response to Judge Millett's questions that the court did not find a risk of a mass casualty event. It looks like here the court's saying the defendant created a serious risk that multiple individuals could have been killed or injured.
That's correct. The court did say this. And my recollection
And he said
of
something different in sentencing.
my recollection of the court's statement about mass casualty was at the later sentencing hearing, and the government was saying that he was essentially going to have created a mass casualty situation. And the court was simply stating that it had not made that specific finding in this July 27th decision.
Let me ask you.
But I mean, mass casualty was not specific, but the court is saying that he's talking in this decision that he is saying that it created a serious risk to multiple.
The guideline is phrased in a way that I find a little bit less precise than I wish. And in part, it's that it's in the passive voice, at least part of it. So let me pull it up. You give me 1 second. If national security, public health, or safety was significantly endangered, is it supposed to be if safety was significantly endangered by the nature and circumstances of the offense? Is that, I guess, significantly endangered by what or who? What are we supposed to look to? The defendant himself, like how dangerous was he as a person? The offense itself? It says nature and circumstances of the offense. So
Right. I believe it's the offense. Other courts have looked at not just the offense, but
just
what
the offense? Not even the what work is
nature and
what work is
circumstances.
nature and circumstances doing there?
It can be both. I mean, the nature and circumstances of the offense would include, you know, who this defendant is, how he's acting, what his statements have been, and so forth. But other cases in other circuits have looked at not just the offense itself. There are some cases from the 1990s where courts looked at what the defendant's prior criminal history was in determining what his endangerment to the public would be if he's let out. I believe the Jones case and
Go ahead, sorry.
the Jones case, I believe the Brown case from the 11th Circuit, both looked at the nature of the defendant's whole history.
Okay, and then hopefully very quickly, the finding that this guideline applies, what does that get? Is that an application of law to fact? Is that a due deference?
I believe so, yes, Your Honor.
Okay.
It is due deference. And there isn't any point in which the district court in its decision is going through any sort of legal analysis of what the specific words of the guideline means. We don't think this is a de novo legal review. And given the full facts of the case and everything the defendant has said about his intent and what he planned to do with that AK-47, I believing that he was buying one that was going to work along with live ammunition, we believe that the court properly applied this enhancement in this case.
Can I ask you what, there's more of the guideline I don't understand as well. What does time of the offense mean?
We believe in this situation, the time of the offense is the whole time that he is causing the transport of the gun across state lines. So here you have him on 31st of March, sitting down watching an ISIS documentary with CS3 and saying that he wants an AK-47. Then he's paying for it in 2 installments through April, and then he gets it on the 4th of May. So we believe that the entire combination.
Any point in that time frame, and that makes sense to me. There was any point in that time frame when he was in fact in simultaneous possession of the machete and the AK-47?
Only on the 4th when it was the CS3.
He wasn't in possession of it. It was, what, a few floors away in the building.
They were in the same building.
In the same building. That counts as in possession. I mean, the district court said he was in possession of multiple weapons. That counts as in possession? When I'm asking you as a matter of thought.
Yes.
Is there some case you can help me to understand that?
I mean, not off the top of my head, but it's in his apartment.
You've seen,
It's
his
in
apartment was a block away. Would he still be in possession of multiple weapons at the time he acquired the AK-47?
That would be a more difficult case, but
Okay.
since they're right in the same apartment building, we don't believe.
Same apartment building, but if it's 10 floors between it, you have to go to the elevator. Are they in? I mean, I just don't understand this
Yeah.
concept of possession. If it's in the same building, no matter how big the building, in the Pentagon, which is an incredibly big place, right?
Right.
That wouldn't be possession of something if you're on one corner and something else is in the other corner. I mean, I don't know.
It's a broader concept than while armed. So it's not like it has to be immediately at your
No,
side.
but I've seen plenty of cases where it's in the next room.
Right.
It's in the car and you're standing next to the car. I'm just not aware of one where it is in an entirely different premises that is.
It's a different unit of the apartment.
Excuse me?
It's in a different unit of.
And different
apartment.
floor, 3 floors. I think it was 3 floors away.
Can't
It
recall.
wasn't like it was across the hall, right? I can see your argument about across the hall, but it wasn't even the same floor. It's 3 floors away.
I don't know.
Right.
Council has indicated that it was across the hall to me.
I'm sorry.
Council has indicated that it was across the hall.
The apartment, is that right?
I don't know off the top of my head, Your Honor. I don't
Okay.
want to commit to that, but he certainly had it at the same time and he did possess it. So for all those reasons, we request that you affirm the judgment of the district court. Thank you.
We kept you up too long too. Thank you. Okay, we'll give, Ms. Taramina, we'll give you 2 minutes for rebuttal.
Oh, you're muted.
Oh, you're muted.
I apologize. I just have 3 quick points following up on what was just discussed. What the court said was not that he possessed multiple weapons at the time. He said he was armed with multiple weapons. And I think that the government counsel just conceded that that being armed is different even than constructive possession or possession. They're really like the court's words were that he was armed with multiple weapons. And even if I had a gun in my house and walked out of the house and was shot by the police, they would have shot an unarmed individual. And so he was not armed with a machete at the time that he was armed with the AK-47 for one.
Was his apartment across the hall?
That is not in the record, Your Honor. I don't believe that the apartment was across the hall. I do believe I also have a recollection, and I apologize, I can't point to it in the record at this point, that it was on a different floor. But in any event, I am fairly positive that there is nothing in the record that the apartment was across the hall. With respect to this distinction, very simply, I don't believe that this is an application of law to fact. It is a plain language interpretation of what the words "was significantly endangered" mean, and so I believe that him applying this factually impossible, the factual impossible circumstance is evidence of a misinterpretation of the guidelines. So that's how I would frame that issue. And
just to be clear,
finally, yes.
sorry, I promise I'll let you make your finally point.
Yes.
And your position is that this, for this rule of law that was significantly endangered is an objective factual inquiry that does not turn in any way on the defendant's subjective intent, or does subjective intent factor in?
That's where I was going next, Your Honor.
Okay, I apologize.
I think the court has seen and understandably has struggled with, what do we do with intent? Well, what we do with intent is enhance his guideline by a guideline calculation by 4 points for specifically his intent. And that happened in this case. So what 5K 2.14 is aimed at is not intent. It is action that significantly endangered the public safety. These are two different things. And so it really, this departure is to differentiate between the people who have the intent to do something bad and don't do it, and the people who intend to do something bad and do. And that's what this departure is for. And so that is where intent does come into play. It comes into play for the 4-point enhancement within the guideline, and it can also be enhanced with respect to 3553. But it's not, the intent's not just, it is not being unaccounted for. If there's nothing further, Your Honor.
Yes, I have a question.
Yes, Your Honor.
You made much of the gun having been disabled.
Yes.
Would you be making the same argument about its irrelevance as a weapon, about its not being a threat to anyone, if the gun were simply unloaded?
If it were unloaded in the context of this,
Everything else is the same, right? It's
the
just
sting
the gun is
operation,
loaded.
I would be.
So why do you think anyone would bother disabling the gun?
To be extra careful, Your Honor. I mean, we're talking about
Careful because there's a risk.
Significantly in danger, right? So there's a continuum here, and so I think the disabling.
I think the significant endangerment could be met by endangering the officers involved in the arrest.
But they're not endangered with, I believe, with a disabled weapon or one that is unloaded, with no access to ammunition, assuming that there's no access to, like, immediate access to ammunition.
Okay. Thank you.
Thank you very much to both counsel. The case is submitted.
Thank you.
I'm just going to wait a minute for Judge Ginsburg to return.
Case number 22-7110 et al. International Union, United Mine Workers of America, appellant, James Asbury et al. Versus Consol Energy, Inc. and its wholly owned subsidiaries et al. Mr. Fagan for the appellant, Mr. Woodrum for the appellees.
Good morning, Your Honors. Kevin Fagan on behalf, of the United Mine Workers of America. I'd like to reserve 5 minutes for rebuttal. There are two issues before this court. First issue is respect to vacatur and how the district court got the decision with respect to vacatur correct. The second issue is the standing of the United Mine Workers of America. District court decided that the union lacked Article 3 standing, constitutional standing to pursue its confirmation of the underlying arbitration award. I'd like to focus, please, on the vacatur argument initially.
I think maybe we're better to start with
The procedural issues.
standing and then a couple additional questions that we asked counsel to be prepared, because we don't get to merits issues unless we get
Certainly.
to this threshold.
Certainly, Your Honor, my oversight there. 3 questions were posed to the parties on Monday, and we thank you for doing so in advance of this argument. The first question posed was the standing of the subsidiaries to press their cross appeal, seeking vacatur of an arbitration award to which they do not appear to be a party, and by which they do not appear to be bound. It's the UMWA's position that they are indeed a party to this raw decision, and that the record evidence establishes that. The subsidiaries were signatory to the 2011 collective bargaining agreement. That collective bargaining agreement at Article 20 requires them to develop an employer plan, an EBP, an employer benefit plan, which provides lifetime health care benefits to union retirees. It did so through the plan administrator, Consol Energy, parent company. In the district court phase in the Southern District of West Virginia, Judge Faber found that Consol Energy was indeed a plan administrator, was in fact and indeed signatory to the collective bargaining agreement, and quote, the court finds, in fact, indeed, Consol Energy was an agent of the subsidiaries, none of whom have employees or other personnel adequate to make administrative decisions.
Did you say Consol was a signatory?
Yes, Judge
Is there
Faber.
a list of signatories, not including Consol?
Pardon me?
Isn't there a list of signatories at the end of the agreement, not including Consol?
Judge Faber found that they were signatory to the collective bargaining agreement for a few reasons. Number one, their chairman, Mr. Nicholas DeOlius, was the chairman of the BCOA, the Bituminous Coal Operators Association, which is the multi-employer group that negotiates on behalf of its members. Mr. DeOlius also signed certain side letters of agreement appended to the collective bargaining agreement. And based on that, Judge Faber found that Consol Energy, parent company, was a signatory to the contract. Yes.
I think what we're talking about is who was a party to the arbitration and against whom does the arbitration award run?
Well, Judge Faber found them to be the real party in interest.
I'm asking you,
Pardon me?
I'm going to ask you a direct question. Is anyone other than Consol Energy named as a defendant in the arbitration?
Well, the raw decision itself speaks to the subsidiaries and speaks to the fact that Consol Energy was appearing on behalf of the subsidiaries.
Where does it say that?
It says so. Let's see. Under jurisdiction, Your Honor, going to appendix 375. Respondent acts as the plan administrator for certain subsidiary companies that were signatory to the 2011 NBCWA.
Respondent acts as the plan administrator for certain subsidiary companies. The respondent is the plan administrator, Consol. Maybe acting, but I don't, is there an agency finding in the award?
Yes, there were.
In the award?
there was an agency finding by Judge Faber.
I understand. That was after the fact, the
Um,
finding by the trustees.
I don't think there's a specific finding of
Oh,
age.
findings. So again, the respondent is the plan administrator Consol, not the subsidiaries.
I'm getting a little feedback. I'm sorry, Judge.
Right, so find yourself to the arbitration
Right.
itself in that award. The named respondent, you all picked who that would be, and you picked Consol. They were sending the letters. I understand why. You pick Consol and Consol only as a plan administrator.
That's correct.
And the award runs against Consol Energy only.
That's your construction, Your Honor. We would disagree with.
How do you, okay, so as you know, with arbitrations, we don't really, we take them on face value. We don't add to them or subtract from them. So where is it the finding in here that anyone other than a plan administrator was the named respondent to this arbitration?
Your Honor, the conduct engaged in, which gave rise to the dispute between the party, was all in Consol Energy letterhead on behalf of the subsidiary.
Where is, I'm going to ask again, this is just a factual question or content question. Point me to the language where the arbitrators found that in fact, notwithstanding how you all framed the arbitration, there was the subsidiaries themselves were named respondents and are bound by this award.
They are not named in the reward. That is correct, Your Honor.
Okay, and then is there any case authority that lets us, you're arguing that there's an agency thing or, you know, the real party in fact or something like that, but is there any case authority that federal courts, either under the MLRA or I guess if we have a Federal Arbitration Act case, we can think about it,
I think-
can rewrite the award to say it runs against entities who are not named?
There's no case law that says that they can rewrite the award.
But we have to take the award as given.
Certainly.
So back again to how they standing for their counterclaims if they are not a party to the award or the arbitration,
Well,
can't be enforced against them.
I think you can't make that determination without considering the status of the subsidiaries. The record establishes that the subsidiaries, Judge Faber recognizes, had no administrative construct. They were a shell company. They had no
So,
person.
none of that's in this award. None of that's in their decision, trustee's decision or the award. So is your point that you wanted to use the confirmation process to not just confirm the award, but then make sort of factual and legal determinations about against whom the award legally operates?
Your Honor, we would argue that Consol and the subs are the same.
I understand you would argue that.
And I am arguing.
But you
Yes.
can argue that all day.
Right.
But you've also agreed that the trustees made no such finding. There's nothing in
Trustees
the
discuss the employer, and the employer in this decision is
the trustees
Consol.
made such no finding. When you confirm this award, you're confirming it against Consol.
Yes, but what?
Yes.
Why do you want to be bound by this award? It's adverse.
Sorry?
Why do you want so badly to be bound by this arbitration award?
We want the subsidiaries to be bound, Judge,
Yeah, why?
because they've undertaken a contractual commitment to provide lifetime health care to our retiree beneficiaries.
This award was filed by an employee, and the grievance he filed was affirmed. The arbitrator said, yes, employee, you are right. And so we're going to issue this award binding the respondent, which, as Judge Millett has pointed out, and as you have conceded, is the plan administrator, right there, page 375. The respondent, singular, acts as the plan administrator. And just to be clear, the subsidiaries were not plan administrators at this time, right?
No,
Consol was the only plan.
they let their parent company, I assume the parent company
So
dictated to the subs.
here's an award adverse to the plan administrator. It's not adverse to the subsidiaries, but you seem to want the subsidiaries to be bound by an award that would be adverse to them.
The trustees in this decision, in effect, enjoined plan administrator from making any post-contract changes to the level of benefits. Of course, we want that to apply to Consol's owned subsidiary.
Are they the current plan? Who is the plan administrator since Consol disappeared 6 years ago?
That's a good question, Your Honor. As far as we could tell, there was a series of restructurings. We think the publicly traded entity known as Consol Energy is the plan administrator.
So not the subsidiaries.
That's correct. And if you look at the record,
So if we were to substitute in the replacement, the successor plan administrator, it would not be the subsidiaries. It would be Consol round two.
It would be the successor to the plan
Consol,
administrator,
not the subsidiary.
the subsequent plan administrator. When Mr. Salvatore, who's the HR director of Consol Energy, was asked in his 30B6 deposition whether the subsidiaries had any personnel or had any ability to administer these plans, he said no. And he said that is done by our corporate parent.
Right, so subsidiaries have no ability to administer this plan. You just said that.
They have.
And so they can't,
They-
what do you want from them? They're not the ones administering it. They're not
We-
the ones
we
that can
want-
make the change the console that no longer exists was threatening.
Certainly. We want the injunction, basically, that the ROD trustees developed to apply to the signatories to the contract, the
You
subsidiaries,
should have named them. in
who
your
are all out of
proclamation.
business, by the way, Judge. And they only operate, as Mr. Salvatore admitted, to administer its lingering, their residual contractual commitments, one of which is.
Do this through this entity, you're assuming they're doing it through this entity that we'll call Consol 2 or whatever, this new entity that's nowhere in the award, wouldn't be bound. I mean, I'm a little confused about why we're supposed to confirm an award against an entity that doesn't exist.
Well, Your Honor, if the court deems that there's further factual finding that needed on that issue,
Well,
the
first, we're trying to
single,
figure out standing.
I'm sorry?
So first, we're trying to figure out whether, because the subsidiaries have filed counterclaims.
That's
And we're trying to figure out whether they have Article 3 standing to have done that.
That's
And
right.
You're,
And I wouldn't presume to speak on behalf of Mr. Woodrum and his
you
client.
began your argument
his
by saying
client.
you think they do have standing because you think they're bound by this
But
agreement.
we absolutely have maintained that throughout this litigation,
Okay.
that the subs are signatory, they had a plan administrator, they obviously speak to one another.
Do you have any case, are there I just don't know under the NLRB, are there any cases that say a labor arbitration decision against an agent automatically encompasses and binds the principles?
Judge Faber in his footnote 12 says, case law further supports this court's previous ruling. He cites a case, finding a single employer where interrelation of operations, common ownership, or centralized control of labor relations are present. J.R. Ryan v. Sons, that's,
That requires factual findings.
I understand. When the charges against the parent company and its sub are based on the same facts and are inherently inseparable, a court may refer claims against the parent to arbitration, even though the parent is not formally a party to the arbitration agreement.
Mhm.
That's set forth in his decision.
Right, that's a different question about whether Consol, Ginsburg was saying, that's whether Consol can be named here as a party to the arbitration, but we take that as given.
With all due respect, and I mean this with all due respect, anybody in the coal field, anyone in the coal field, nobody ever says, hey, I'm employed by Helvetia. We never received a letter from Helvetia. We didn't receive a letter from Laurel Run Mining, Aminati. Never
It'd
received
be
that.
great factual evidence.
Everybody who works for Consol knows that they work through Consol through what used to be Score's subsidiary. Consol is the real party in interest here. And as I stated previously, Your Honors, if there's a dispute about that, or if you're not convinced of that, perhaps there needs to be additional fact finding in that area.
Okay, and then there were two other questions about
Certainly.
the way this case was.
Not avoiding the question.
No, you're not. I've distracted you with a question on this one.
The second question is, under what authority did the district court dismiss counts 3 and 4 of the subs counterclaim? As I initially indicated, Judge, I would defer to Mr. Woodrum. It's his counterclaim, and I wouldn't deem to speak on his behalf. The third
Well,
question,
you have filed an appeal from what I think you assumed was a final judgment. So why were you convinced that you had a final judgment to appeal?
well, what we tried to do when we met, the court initially remanded this case because there was summary judgment. And the court said, you don't have a final appeal. So what we did do is we went back to the district court, and Mr. Woodrum and myself and Judge Nichols, we worked to try to prune the case, to try to limit the issues as much as we could. And we did that in undertaking in good faith. I don't know why Mr. Woodrum decided to take a dismissal on those 2 counts. I do know why we decided not to file additional summary judgment motion with respect to counts 1 and 2. And that is because the count 1 and count 2 both asserted that, or Consol Energy was or the subs were asserting that the ROD trustees did not have the authority to decide the dispute. In essence, Your Honor, an arbitrability determination.
The subsidiaries filed 5 counterclaims against you, correct?
That's correct.
And claims 3 through 5, the district court said they are dismissed and they've been voluntarily dismissed. Am I right so far?
Correct.
Okay. Under what rule of civil procedure did the court take that action?
Well, it doesn't, the ruling, as far as I can recall, does not speak to Rule 40. And I understand that the entire action was not dealt with in Judge Faber's decision. But I will speak to the last question that was posed to the union, Your Honor. And that is why.
Just before you turn to that one.
Sure.
I'm looking for a number. Sorry.
No, you go ahead and answer.
No, please.
No, if there was a violation of Rule 41, is that itself jurisdictional though? Or is that just I mean, district courts people argue all the time that district courts violated 12b-6. But that doesn't mean there's not a final judgment, just if there was a procedural misstep, right?
The rule says what it says. I would defer to the court's judgment on that rule. In fact, the entire action was not disposed of in the Rule 41 motion, and it was under the auspices of a court order. So the second provision of Rule 41 would apply. Is it jurisdictional? I'd like to say it isn't. I don't have a case to point to you right
There's
now.
lots of Supreme Court precedent from this court that we don't treat every violation of a rule or a statute as having jurisdictional consequences, defining jurisdictional consequences unless it's very explicit. This rule is not explicit. So maybe there was a mistake, but
I think what happened,
whether there's a final judgment here, the district court said it was in complete control, entered an order, said it's a final judgment, wrapped up everything, disposed of all claims, maybe mistakenly disposed of a claim, but we hear appeals all the time from people who say the district court mistakenly disposed of a claim. But there's no doubt the district court was in control here and wrapped everything up in a single final judgment.
yes. And I think Mr. Woodrum, and I'll speak on behalf of myself, what the union certainly did was look to the judge's September 30 decision, wherein he found 2 things. He found that the dispute was arbitrable, right? And he also found that it drew its essence from the collective bargaining agreement. He would be the second federal judge who found the dispute to be arbitrable, because before Judge Faber can enter his order enjoining the company from further changes in compelling arbitration, a predicate to that is the finding that the dispute is arbitrable. So I think that the parties were laboring under that understanding.
Preliminary injunction.
Sorry, Judge?
Preliminary injunction.
That's correct.
And was there any factual finding or conclusion with regard to arbitrability? It seems to me it was sort of a standstill order.
I believe a reading of Judge Faber's decision of March 17, 2017 reveals that he found the dispute to be arbitrable.
Did you say that?
You were likely to
And he compelled arbitration, Judge.
Compelled arbitration.
Compelled arbitration.
Right. But
And
it would still be for the arbitrators to determine whether it was arbitrable.
Well, typically, the courts decide arbitrability unless there's an explicit agreement and there's all right, it's unambiguous. There's no ambiguity with respect to that issue. But the trustees, so here we have belt and suspenders.
You didn't have that kind, did you have that kind of language here, or was it for the district court to decide?
We have language that says in the collective bargaining agreement that all disputes arising under Article 20 are under the jurisdiction and purview of the ROD trustees. So I would argue, yes, we do have that language. And I think Judge Faber independently.
That count as a type of unambiguous language that allows the arbitrators to decide it, or was this arbitrability for a court to decide?
I
It
think,
has to be unambiguous.
I think that the language of the contract is unambiguous. I think that the ROD trustees.
What did the district court judge find? Did he find that it was his decision whether it was arbitrable and that was a decision he was making? Or did he find that it's for the arbitrators to decide?
He didn't preface it, Judge. He just found it that they had the authority to render a decision with respect to the dispute. Now, under the collective bargaining agreement, Article 20 is finally.
I think to issue a preliminary injunction, you also had to find that you were likely to succeed on your arguments.
Right. He also had to
find that you were likely to succeed on your arguments.
And he also had to find imminent harm that still persists to this day. So if you take Judge Faber's decision the day before he issued it, okay, we're in the same posture we were then. This company, Consol Energy, acting as the plan administrator of subsidiaries, communicated on 4 occasions to our retiree group. 2 of those occasions, they said changes are in the office. Okay, we filed the ROD procedure. We filed the injunctive action on December 23, 2016. The ink wasn't dry on that injunctive action before Consol Energy again reached out to our retiree population, and this time they didn't say changes may be in the offing. They said changes have been made.
Those 2017 letters were not within the scope of the arbitration. 2016 letters were. Right?
No, all letters preceded the arbitration. The arbitration award in this case.
Not the filing of the grievance. The grievance was done, you said, in December 2016.
Oh, that's correct.
So the grievance encompassed those 2 communications from 2016, not the communications from 2017. You might have thrown them in for window dressing in your case, but they were, that is not the scope of the grievance. Can the trustees expand the scope of the grievance?
Well, they certainly considered all the communications.
I'm just asking, can they and did they extend the scope of the grievance?
Well, the question posed to the ROD trustees was not based on, may have been based on those letters, but the question posed and articulated by the trustees was whether the respondent could make post-termination changes to the healthcare plan. But they had nothing to do directly with those letters. Now, of course, they did consider the second batch of letters, and I think this is extraordinarily important for standing purposes. On January 12th, 2017, Consol Energy, on behalf of its subsidiaries, sent what's called a summary of material modifications to retired coal miners with healthcare issues, an aged and vulnerable population. And they set forth 4 parameters. They said, this notice is to inform you that effective January 1, 2017, 11 days before, the plan listed above was amended. They made 2 ministerial changes. They changed the name of the plan. They excluded certain companies that have gone out of business. But here, and crucially, they said the administration section was amended to take into account the expiration of all relevant bargaining agreements, thereby eliminating the ROD process. So by fiat, they told our retiree population that there was no more ROD process. And in fact,
Understand that letter. I've seen the letter. The trustees did not address changes to the arbitral or the decision-making process, the dispute resolution process. They addressed threatened, in your view, threatened changes or proposed changes to benefits.
that's correct.
And that's what the injunction was, that no change in benefits.
Now, benefit levels, the ROD dispute
Okay, so
process.
did that enjoin
Well, there was.
changing the plan dispute resolution process?
Well, this one letter just speaks to these changes. They also required that if the plan administrator was unable to resolve the dispute, any disputant would have to file a lawsuit in the Western District of Pennsylvania.
That's
So
not what I'm asking. I'm asking, you're here on confirmation of an arbitral award. And the arbitral award was focused on,
I was going to get to the
Okay,
changes.
well, I'm just trying to get right to it because I don't I'm not here to talk about their changes or asserted changes.
They can't make changes to the plan.
The
That includes
injunction, the
changes.
order- Hey, where does the award, let's go back.
Yep.
Say they can't make any changes.
So
plan.
the award, any of the trustees, pursuant to Article 20, et cetera, trustees have the authority to adjudicate the ROD. The trustees recognize that the respondent may make modifications or changes to the health benefit plan for which it is the plan administrator after the expiration of the
Modification or changes in the employee benefit plan. Is the dispute resolution process in the employee benefit plan?
Yes, it's part and parcel. Part and
Part
parcel.
of the employee benefit plan? Where
It's-
is it in the, okay, we have the model employee benefit plan in
It's-
front of us. Where is it?
It's set forth in the model benefit plan. It's set forth in the employer benefit plan.
What page?
It's set forth in the collective bargaining.
No. It may be other places. I'm talking about what the trustees were dealing with here. What page? I mean, I just missed it then when I was looking at it in the
Just a moment on the model plan, Your Honor.
471, and a few pages after that. Where does it talk about the dispute resolution process?
Yeah, 472 administration. And this basically echoes what's in the contract. Plan administrator is authorized to promulgate rules. The trustees of the health retirement funds will resolve any disputes, et cetera, any disputes. And that's echoed in the EBP, and it's set forth in the collective bargaining agreement as well. So not only can they not diminish the level of benefits, they can't just by fiat say there's no more ROD process. The ROD process is a crucial administrative component of the employer benefit plan. Been extant since 1978. It's been final and binding on the parties since 1981. From our estimation, we believe Consol Energy has been party to 9 agreements since that language has appeared in collective bargaining agreements. The ROD trustees also did something else that's of significance, Judge, Your Honors. What they did is they reviewed the contractual language, the employer benefit plan, the model plan, as you indicated. They considered the submissions of the parties. They considered the injunctive hearing, and they also considered previous ROD decisions. One of those ROD decisions, tellingly, was a post-expiration ROD decision. Now, under the terms of Article 20, ROD decisions become precedent. They become part and parcel of the collective bargaining agreement. The ROD decision issued by the, referenced by the trustees, ROD decision 88-711, was post-expiration. Okay, since the issuance of that, Consol Energy, its subsidiaries, none of the Consol family of companies have made any effort to negotiate a change in that. So any claim that the ROD process does not survive the termination of the collective bargaining agreement is belied by specific contract principles of construction and certainly belied by the fact that post-termination disputes have previously been resolved by the trustees.
Got that. And so those changes in those letters never happened because you got the preliminary injunction.
That's exactly right, Your Honor.
And then the trustee award comes down.
Correct?
It says Consol can't make any changes to the.
As plan administrator,
Yes, as plan administrator, can't make any changes without negotiation.
any
Correct.
post-expiration,
Expiration without negotiation.
that is without agreement.
Agreement, thank you. Can't do that. Okay, that's who this award runs against. That Consol plan administrator no longer exists. The entity named and ordered not to make any changes by this confirmation, by this award, no longer exists,
Well,
right?
it no longer exists in that
Right.
form. Yes. They've-
Right, no longer
they've-
exists.
Judge,
You
if I,
did you substitute in?
you need a program here to follow the players, but
Well,
what
it's not
happened?
just that we need a program, is that there's sort of legal consequences to whether people, when people are substituted or not. When one entity disappears and no one's substituted in, I mean, I didn't see anything in your third amended complaint seeking confirmation of this award that said we actually want to change the entity against which the award runs. I mean, there's one way to read your complaint is saying not just confirm, but actually reinterpret, update, change the operative target, and then confirm. Is that what you intended to do? Or did
but-
you just want this award confirmed, no changes, no
At the
adjustments?
time this award issued, Consol was the plan
At
administrator.
the time of your third amendment complaint, were you
Right.
asking the district court to just flat out confirm, don't touch anything, don't do anything, don't say anything, just confirm? Or were you asking in your complaint for the court to first make clear that this award runs against either the subsidiaries or, which you now told us at argument is this new Consol
We
entity?
think the form is sufficient, and here's
And it's sufficient because
another
how are you
try.
injured? Yeah, well, I want to stay focused on
Another try,
injury.
Judge. The trustees said no changes to the plan administered by Consol Energy. Exactly.
It said.
But the contractual, I,
It said Consol, no changes to the plan.
to the plan, which the subsidiaries, which applies to the subsidiaries' contractual commitment to provide benefits.
What good? I'm just not understanding what good is it to you? What is redress by an order confirming an award, regulating behavior by an entity that no longer exists?
Well, the current action is against the subsidiaries. So we're arguing that it
Okay.
doesn't run to
So then-
Consol. It runs to the
So
subsidiaries.
you're arguing. Explain to me how this works under the LMRA. If you confirm an award against an entity that no longer exists, how does that award do anything to the subsidiaries?
Well, let's imagine that the subsidiary said, hello, parent company, we're not happy with the way you're administering our plan. We're going to substitute another plan administrator. Would this decision obtain? Absolutely. It doesn't matter who the plan administrator is. The trustees have issued their decision that no post-contractual changes can be made without agreement with the United Mine Workers. That applies.
What authority can you provide me? You do LMRA all the time, I do not. That says if you have an arbitration award confirmed against a single entity that no longer exists, that binds, legally binds, all by itself. Entities not named in the award.
Well, if that were the
Covered
case,
by the award.
if that were
What
the case,
case can you
Judge,
provide me? What legal authority? Is there any such authority?
not off the top of my head, Your Honor, but if that were the case, every adverse decision would be followed by a corporate restructuring.
There's ways to write things. I mean, people do this all the time.
Right, well, Judge
Against-
Nichols, in his opinion,
Against Consol and its subsidiaries.
Judge Nichols-
Name them in the grievance, name them, have them named in the award, and then you're covered. So
I understand
I'm just
that.
trying to understand, no, it's your. it's
I
your case.
understand
I'm
that.
trying to understand how your confirmation is
No,
going to
no.
help you.
and it's well taken, Your Honor, and I don't mean to be combative with you, but we're talking about formalistic approaches here, when in fact, everyone and their brother in this union, it's been around since 1890, knows the Consol, its subs, and everybody at 1100 Consol Avenue up in Pittsburgh are one and the same. Everybody. Mr. Salvatore
I
testified,
didn't know that.
I didn't know that either.
everybody in the full, and
Okay.
How about that?
Sorry.
I'll tell you one person who knew it is the HR administrator for Consol, Mr. Salvatore. He testified that these companies had no employees. He testified that to that during the injunctive hearing. He testified to that 3 years later.
Back in my apologize, but I have to apply. So,
Judge, it
I
seems,
recognize you talked about the 2017 letters, but the trustee's decision said no changes have yet been made. And then the injunction made sure no changes were
trustee's
made.
decision was made post-injunction. And the trustees made mention of the fact that changes were not made because of the extant injunction.
So there certainly was a letter threatening, I guess, from your members' views and your view. But there were no changes made at the time of the award. The injunction has long since expired. The injunction has long since expired by its own terms,
Yes.
and still no changes have been made in the intervening 6 years or 4 or 5 years before you went to district court here on your third.
Judge, I'll tell you why that is. I'll tell you, yes, I'll tell you why that.
Actually, that's right, though.
Correct. And I'll tell you why that is. When the UMW approached Judge Faber in the Southern District and said, hey, we want to file a second amended complaint, the judge issued and I'm not sure, I think that was opposed by Mr. Woodrum and his clients. But the judge issued a decision, and his decision was May 21, 2018. And he basically said, you know, the union wanted to include a count to continue the preliminary injunction until the court confirms the arbitration decision. At the hearing, the May 10, 2018 hearing, counsel for plaintiffs requested the court strike this count in light of defendants' representation that it would continue to offer retirees the benefits available under the employer plan until the conclusion of this action. That lone assertion is the only thing.
What page of the JA is that?
I'm sorry, I apologize. That would be 315. The decision begins. I think footnote 5 is the joint appendix 315.
Sorry, the language that you were reading about they agree not to make any changes to litigation is over?
Yeah, during dependency of this litigation.
Yeah, what page is that?
I believe it's on 315, Your Honor. Wait a minute. It might be. That's where
That's the beginning of the opinion.
That's where the decision starts. It's a footnote 5. It's on page 320. So that promise, we believe, is the only thing that stands between Consol Energy making changes, or the subs making changes to the healthcare plan, because that's the only reference in the record that they would do so. The court has it right that any changes were nullified by the injunctive decision of Judge Faber, and we believe that once this action's concluded, that subsidiaries will continue with making changes to the plan.
What's the line in footnote 5 again that you were reading?
I'm sorry, Your Honor.
What's the line in footnote 5 again that you were reading?
Oh, yes, it's footnote 5. It's at 320, joint appendix 320.
What's the key line?
Oh, the key line. At the hearing, counsel for plaintiffs requested the court strike this count in light of defendants' representation that it would continue to offer retirees the benefits to which they're entitled until the conclusion of this action. So
This action wasn't an action for confirmation.
well, I take that to mean until the conclusion of this litigation. But if it's subject to dispute, that puts us even more tenuous position. And at any point, Consol can say, well, that wasn't part of what we represented to Judge Faber. That's the only thing that we think, Your Honors, that stands between Consol making changes to the plan, the subsidiaries. I apologize. Falling into my own rhetorical device. The subsidiaries making changes to the retiree healthcare plan.
We kept you up here a long time.
Thank you very much.
May I begin? Good morning, Your Honors. My name is John Woodrum. I represent the companies in this matter. I first will respond to the jurisdictional issues you presented in the per curiam order.
So I had a question.
Yes, ma'am.
Do you agree that this new Consol is the plan administrator or the subsidiaries themselves the plan administrator, or is there no difference?
My understanding that the new parent corporation is the plan administrator of this continuing plan. But the new administrator has no corporate relation to what is now known as CNX, which was the plan administrator during this period. These companies were, as part of a larger package, spun off, and they exist under a separate publicly traded company at this time, and have really since the month that the arbitration decision came down is when the restructuring occurred. So the old plan administrator has not been in that position since almost the date decision came down.
So the new plan administrator, you're here on behalf of the new plan administrator, is that correct?
I'm sorry, sir.
Are you here on behalf of the new plan administrator as well as the subsidiaries?
No, I'm only here for the subsidiaries. The new plan administrator is not a party to the case at all.
Can you then go to the first question in the order that was asked about, are the subsidiaries parties to the 2017 arbitration award? And are they bound by the 2017 arbitration?
No, Your Honor, they are not. And from the very time this ROD was filed, they protested it under, they submitted a response under protest to the panel, to the trustees.
So they weren't a party to the arbitration award, right?
That they were not named in it, and they specifically in their protest, response under protest, they noted that Consol Energy, who was the named party, had no employees, had never employed these people, and never been.
And they weren't bound by it.
And
they were not bound by the 2017 arbitration award, correct?
correct.
Okay, then how is it that the subsidiaries have standing to challenge the arbitration award?
Well, that's the essential question that you put to us in your per curiam order. And the reason we have standing is because, though not a party to the award very directly impacts us. We are harmed by the award because it's our plan. We did the bargaining about it. Insofar as there are changes to be made in the future, we will be the ones negotiating with the union. Yet in the award, the trustees reserved their jurisdiction, even though we're no longer signatory to an agreement.
And I don't know the answer. It's not a rhetorical question. If you were to then just defy the award and, change what the award says can't be changed, and then you get sued for that, wouldn't you have a good defense? We're allowed to make those changes because we weren't a party to the arbitration award in 2017, and we're not bound by the arbitration award in 2017.
We would certainly make that defense.
Then why do you need us to decide that question now when a court could decide that question when there's actually a case controversy?
Because the award, if the award is not vacated, it remains. Arbitration awards don't have to be confirmed in order to retain vitality. So the award itself will remain.
But you're not bound by it.
We're not bound by it, but the problem we would face in the real world is the union would promptly file a grievance with the trustees who have said that they have continuing.
I mean, it sounds like, I get that, but it sounds like you want our court to issue you an advisory opinion today so that you can use it in different disputes down the road.
No, Your Honor, we're not asking you for an advisory opinion. We're simply asking you to vacate this award. Don't pull back and say, we don't have any jurisdiction here, because the award will stand if it's not vacated. And the award itself says that these trusts, we would have to relitigate everything that we've been litigating for the last 6-7 years.
Do you have any precedent on your side that is analogous to this situation where what's happened is there's been an arbitration award that does not bind the plaintiff, but the plaintiff wants an Article III court to declare the arbitration award invalid, to vacate it, because it's having some kind of collateral effect on the plaintiff?
Not directly on point, and it's partly a function of the very strange way which this case has evolved. We found an analogous situation under the environmental statute. So there's a Fourth Circuit decision that involved harm to a downstream individual who felt that certain facility was going to pollute a river and harm it. And the Fourth Circuit said that it had standing because as a downstream entity, it could be harmed. And in our case, not only could we be harmed, we feel we are harmed because the arbitrators decided that they would, until all the retirees are dead, they have the right to resolve disputes, any dispute that comes under this plan, notwithstanding that the contract itself, the 2011 agreement, gave the signatories, my clients, the authority to amend the plan unilaterally after the contract terminated. So the contract terminated, they amended their plan to say that this panel no longer has any role in adjudicating disputes under the plan, yet the trustee's decision, panel's decision, says we do.
Okay, but could you make any of the changes you referenced in response to Judge Walker that you want to make directly, or would you have to do them through this new plan administrator? Who would actually implement the change?
Well, the plan, the companies are responsible for the plan. They are the plan sponsors. They designated.
Who makes the changes, though? Do you direct Consol to make the changes? This is new Consol, because it seemed in the first round of all this, it was the plan administrator that was announcing the changes.
Right. It's my understanding that the plan is still in effect. The only thing that's changed because.
I'm not asking whether the plan is still in effect. It's certainly still in effect for retirees that were covered by this time window in the collective bargaining agreement. But what I'm asking you is really, in the first round, what set all this off was companies, employers wanted to make changes, but they didn't announce it directly. They had the plan administrator notify the beneficiaries of proposed changes in the 2016 letters and actual upcoming changes in the 2017 letters. And so I'm just asking whether that structure would continue now. That would you yourselves be the ones that would make the changes, or is that's why you all have a plan administrator? You tell them what to do and then they notify beneficiaries, here's what's changing.
The latter, Your Honor.
So is Consol too your agent?
Consol.
The new Consol.
The new Consol is my understanding. We don't represent them and they're not in the case, but it's my understanding. I've been told that the new Consol is the plan administrator.
No, I get they're the plan administrator, but what you should know is the new plan administrator your agent, your client's agent? Because the district court found at the preliminary injunction stage that the first Consol was the agent of the subsidiaries. And it sounds to me from your answer to my question that the same would continue now, that this new plan administrator, new Consol, for at least these purposes, is your agent, because that's to whom you would go. Assume there's no trustee decision or anything like that. That's how the process works to make.
I think administratively, that is likely how the process would work.
So the new Consol is the subsidiary's agent for these purposes.
would be the agent for purposes of handling making the changes in the sense of changing the plan, but it's always the subsidiary's
Make the decision.
responsibility to, because they have the contractual obligation. The parent, the non-signatory parent plan administrator does not have the contractual authority to make the changes. Therefore, it doesn't have the legal authority. It would derive from the signatories themselves.
Because I know you and your clients have maintained for years and years that you are not bound by this
Correct.
agreement, but if the one that binds is just your agent, can an agent be bound but the principal not?
And this issue came up in Consol Energy's appeal of Judge Faber's preliminary injunction.
Moot, so.
That very issue was one of the key issues in the case. And in oral argument, the court, I think it was Judge Niemeyer, made the point that an agent binds the principal, i.e. the companies, doesn't bind the agent. So did I get that back?
Right, so if the agent binds the principal, then you are bound by this award.
The acts of our agent, yes. But the decision to make changes to the plan.
Hey, crazy.
That's it.
Excuse me, I don't know what that was. Your comment was not crazy?
I need help.
It was Alexa.
I'm a ventriloquist on the side.
So you could decide you want to make change, but you can't make them because if one were to assume that new Consol would be bound by this confirmation word, just like old Consol.
No, I don't. I mean, we're not bound to it. It wasn't issued against us.
It's told us the whole reason you have an injury is you can't make changes with this thing. How can you, this is what I'm not understanding. How can you both not be bound by it, as you said, and yet be bound in a way that injures you because it keeps you from making any changes?
Because the arbitration decision, though not directed to the subsidiaries, remains a valid decision at this point. It's never been vacated. It's a decision that's out there by this panel. And going forward, anything that these companies do will be challenged by the union as
things are going to be challenged. You're going to argue we're not legally bound. And that if there is such a challenge, you're going to say, what are you all bothering us for? We're not, you can have your award against an entity that doesn't exist. We're not bound by it.
Not bound by it, but it does provide precedent. What's going to happen as a practical matter, and I think probably.
But precedent, maybe I'm being too court versus arbitrator about this. A long line of people could come up in any case and say, judges, if you rule way X, that's going to bind me in the future, but they are not parties and they're not bound by our decision. And there's no way they have article of standing. Maybe they'll come in as an amicus, but they don't have article of standing because we could create a precedent that could affect them in a dispute, maybe if they have one in the future.
I agree that that is a position we would take, that we're not bound to the decision, but what will happen
It's going to be a pain for you.
Pardon?
It's going to be a pain for you.
Oh, it's going to put us right back through this cycle again, because the union will file a rod with the trustees who've already said that their authority survives the labor agreement, even though we're no longer a signatory. They will file that rod and they will go into federal court, probably in West Virginia, and get it enforced. And then we're back in the soup. The only way to prevent that and create a level playing field is to vacate what is obviously a defective arbitration decision. It's defective because it's against the wrong party or a non-signatory entity that's not subject to the arbitration.
And could you make that argument to future arbitrators? In other words, do arbitrators have the authority to overturn past arbitral awards?
This particular labor contract, as I recall, if the provision is still in there, says that prior arbitration decisions are precedential. But an arbitrator is not bound to follow a prior arbitration decision in the way that judges would be by other decisions of panels in this court, for example. So it would be, I'm sure, taken into account by a new arbitrator.
But you could persuade a future arbitrator that there were enough flaws in the 2017 award such that the future arbitrator should act contrary to the 2017 award.
Well, we would first argue that that arbitrator has no authority. And then we would
That would be
be,
another way to get out of it.
we would be compelled, I suspect this is the way it would happen. We would then be subject to, we'd seek to stop the arbitration, which is what we tried to do in this case in the first place. We would either win or lose on that basis. If we lost, and I think in some courts that have protected these processes, we might well, or that the companies might well be brought back in and then be subject to an order to compel arbitration. We would make those arguments to the new arbitrator and say, in response to the union's argument that this issue's been decided, the trustees have already decided they have the authority, and it's not a general authority. It involved this plan. We can't say that, oh, that was some other company with some different plan. It's this very plan that this invalid decision purports to interpret and enforce. So we would have that burden to bear with a new arbitrator, and then we would have to go back through the process that we've just been through in order to determine that we have the legal right to administer our retiree benefit plan according to the terms of the plan.
You don't administer it.
Pardon?
You don't administer it,
Well, it's administered by our plan administrator.
your agent.
So I stand corrected on the technical use of that. We don't administer it, but it's our plan, and our plan administrator has to do what we tell them as long as it's lawful. So it's our plan, and therefore we.
So you said as long as it's lawful, so if you said to new plan administrator, make this change to these retirees' benefits, could the plan administrator do that with this arbitral award pending? Out there, not pending.
It would violate the award.
So would it be lawful for the plan? You just said.
Yes.
The plan administrator does what you tell them unless it's unlawful, and so it would be unlawful and the plan administrator couldn't make the change?
We would argue it's very lawful because we're not bound by, I'm just saying, I agree
And
with
you
Judge
don't- but
Walker that.
You don't need us to do anything for you today. You already have the lawful authority to do what you want to do.
We believe so,
So.
but it's only lawful
and
as long as the
it's-
court says it is.
And it's your, burden to show standing, and under your own theory, under your own admission, you're not injured by the current state of the law.
We believe we are injured because
You're
there
allowed
is,
to do everything you want to do under the current state of the law, because that one arbitration award from 2017 is invalid. So it's not actually binding you.
that's what we say.
It sounds like you're saying you don't have standing because you're not injured.
Is your injury that you're gonna have to go through all this litigation procedure and arbitration procedure again? That's the injury?
That's the injury. Yes, Your Honor.
That's not an Article 3 injury.
Well, it's harm to us because we are inhibited by an arbitration decision that purportedly interpreted our plan, which is not, we can't be held in contempt for violating because it's not against us. But if we make a change, we are in violation of an extant arbitration award, which says that these trustees have perpetual authority to decide disputes, whether or not you're signatory to a contract.
So I'll make sure I got this. if this, you're standing to oppose confirmation is clear, right? You just want to be able to actually seek vacature in addition, right?
We
Okay,
need
now,
vacator, yes, sir.
If you're not in a position to seek or get vacature, and the court says we deny the request for confirmation on the ground that you're not a party to the award, some arbitrator later is going to bind you?
We run that risk because there's a valid arbitration award and we have a district court decision that says the trustees had that authority. So it becomes murky as to how that would turn out. We believe we are right under the law, but we would have to go through that process and take that risk again. So we are, as I said, we are inhibited from making changes because we know what lies ahead if in fact this award is not just simply vacated as being violative of the trustee's
Judge
authority.
Pickles, at the end of his 2022 decision, says the subsidiaries acknowledge their obligation, their quote, obligation to provide health benefits to eligible retirees post-expiration. Is that accurate?
We do have a contractual, a commitment in the expired contract to continue to provide benefits to retirees. It's sort of analogous to a continuing term and condition. So we have that obligation under the expired agreement, and we agreed to it, and we're doing it. I mean, we never proposed to terminate benefits. That was never the issue in this case, and the case wasn't about that. The only issue in the case was we wanted to provide them differently.
You wanted to change. Well, that's very much disputed whether.
Right, and that's in dispute. And we don't mind litigating that issue. We just don't think these trustees are the proper parties to hear that issue because we didn't agree that anything we do after the contract expired could be decided or resolved by this panel. We're prepared to defend any changes we may make, even under that ongoing requirement that we continue to provide. All we agreed to in the contract was to continue to provide their benefits at the benefit levels. So if we change something that a retiree or the union thinks violates that, they have other federal court remedies that they can pursue to challenge that. The only issue in this case, in this arbitration, is that these arbitrators don't have the authority to do that. And so that decision should be vacated.
Can I ask, maybe this is a more straightforward question than all this standing stuff. And that is, the jurisdictional basis for your counterclaims is Labor Management Relations Act, correct?
Correct.
What contract violation have you claimed? Because the jurisdiction is for violations of contracts. What contract violation do you say UMW did?
Well, I think the courts have held in, it's a good question, but I think it's been resolved. I think the courts have said that a suit to vacate is an action under 301. So we believe that.
A suit to vacate when there's been no violation of a contract?
Well, it's the arbitration. The arbitration decision exists, and a suit to vacate the arbitration decision. The decision's there until it's vacated by a court. So
And
you can't get.
if the arbitral decision was not the product itself of a contract violation. So just assume for purposes of this question that there's no, what if there's no Labor Management Relations Act jurisdiction over the suit to confirm because there's no alleged violation of a contract. And I think courts have also said anticipatory violations aren't good enough.
Right.
Fear that a violation could happen.
Well, it is.
Then your jurisdiction would disappear as well.
It's a circular problem, a conundrum in that.
Yours rise or falls with whether there's actually, they've established a violation
Right.
of Labor Management Relations Act.
Our argument is that there is a violation of the contract because the panel, an arbitration panel wrongly decided an arbitration or an issue under the contract, which the union in its complaint is trying to enforce against us, even though we're not a named party to the arbitration, because the arbitration decision interprets our obligations under a benefit plan. So this case, that count was originally filed, I think the day the contract expired. So we filed in Pennsylvania, and that case, long story, but it ended up getting merged in, consolidated with the union's case here. So
What cases say that vacature of an award by
Pardon?
itself, what cases, is it cases from this court or the Supreme Court? Have said that seeking vacature of an arbitral award satisfies LMRA 301 jurisdiction?
I came across it in reading. I didn't make a note of it because it wasn't an issue at that time, at least, until you presented it to us.
Okay.
So I don't recall
Okay.
that case.
That's
There's been a lot of case reading over the years
I'm sure you
in
have.
this particular action.
One quick question. If you do not have standing for your counterclaims, does that mean that there's no party adverse to the union's one count claim?
If we don't have standing, there is no party because it purports to bind Consol Energy, which is now CNX, which is not even in the frame. And they were dismissed out by Judge Nichols, and the union didn't appeal that dismissal. So I think that's correct, Judge Walker. There is no other way to get relief here.
Usually when there's a corporate reorganization, some entity assumes the liabilities of the predecessor entity. They can't just get out of liabilities that way, otherwise it would be really convenient. Do you know who it was? Was it CNX? Was it this new Consol? Who assumed the liabilities of first Consol?
That was a major corporate transaction. It's documented in SEC filings.
Mhm.
I'm sure that Consol Energy would have retained some obligations. That's almost always the case.
This
when
new
they
Consol
convey-
Energy or CNX?
The CNX, the entity that became CNX, the seller, if you will, retained our seller, sold us or disposed of us, would have retained some obligations with respect. There were many companies involved, not just these subsidiary companies that I represent. So I'm sure that some obligations were retained. I don't know with regard to this specific case what the arrangement was, but there's no damages.
Possible to find out what entity assumed, took over this liability under this confirmation award? That's something we
Well,
can
there's
find
no
out?
liability under the award because there are no damages.
There's
Nothing was ever-
compliance liability. You said that's the whole injury you have here. Someone's supposed to.
I don't know, Your Honor. It's very difficult to measure that kind of a damage. I don't even know whether the parties discussed that or
Wow,
I know
can't
that-
get out of injunctions just by reorganizing.
I know that the parent was certainly aware that these companies had been, they were not signatory at the time of the actual reorganization. So, but they know that they had retiree liability. So I think what the parties most likely addressed was who's going to be responsible going forward for payment of the retiree benefits. And honestly, I don't know
But
the answer.
Consol was the plan administrator. So why would it have any liability at all for
It wouldn't.
the obligations of the subs?
Subject to an injunction. And a confirmation award, subject to an injunction and a confirmation.
Well, there are many categories of UMW retirees, and the parent, not to further complicate this case, but the old Consol Energy was liable for a large group of UMWA retirees under a statute called the Coal Industry Retiree Healthcare Benefit Act. So there are thousands of those retirees.
Okay, so it was by law.
And it was by law that they were made, along with the employers, they were made responsible. So they can't, and their cases have held that they can't transfer that liability. Well, they can negotiate or get an agreement to transfer, that the buyer will assume it. But in the end, if it's not provided, it would come back to CNX. These retirees are not in that position. They're not protected by statute. So it's simply a collective bargaining obligation that would determine where that liability is. And I do not know whether Consol, the old Consol Energy, I don't know who's paying retirees, how they're getting their benefits, but it was a known liability, if you will, Judge Millett, that obligation was going to continue. So I suspect that they did have some understanding about who was going to assume it. Contractually, though, the old Consol would not have the liability because the liability rests with the subsidiaries. So in that sense, neither parent has it. It lies with the subsidiaries, but somebody is providing the benefit.
Thank you. Okay. Thank you very much for your extra time up here too. Appreciate it.
Thank you.
Mr. Fagan, we will give you 3 minutes for rebuttal. I know you asked for 5, but it's been a long morning.
I can do this quickly. Thank you, Mr. Woodrum. Mr. Woodrum gave no compelling reason why this award should be vacated. This award drew its essence from the collective bargaining agreement. I think I might be repeating myself, but it reviewed the plans, the contract language, the submissions not only of Consol, but if you look at Joint Appendix 500, you can see the submission of Mr. Woodrum on behalf of the subsidiaries under protest. The 17-page letter that he writes to the trustees objecting to the process, not to the award. It hadn't issued yet.
That's the kind of the weird thing about this award, because sometimes it talks about respondent singular, the plan administrator, but then it says on J371, the first page of the award, the respondent filed 4 responses to the complaint.
Well, that's right. In
Well,
Mr. Woodrum,
we know Consol filed 0 responses to the complaint. Those 4 responses to the complaint were filed by the subsidiaries, right?
I believe that to be the
Right, but
case.
then they're called, the trustees said it was respondent that filed them. So it seems like there's times that the trustees are treating the subsidiaries and Consol as one and the same. And again, the next paragraph, in his second response, the respondent's legal counsel. Well, that was.
Mr. Woodrum
But
represented.
subsidiaries, a lot of times it treats them as one and the same. As
Subsidiaries.
a position of respondent, and when Consol didn't show up, so I'm just a little confused as to who the trustees thought they were issuing the award against, when respondent singular sometimes means the plan administrator and sometimes means subsidiaries.
Right. In that March 17th letter, Mr. Woodrum makes all those arguments.
No, I'm asking you about the trustee decision. When it refers to respondent in the singular,
Yes.
it sometimes is clearly referring to the subsidiaries, and sometimes it's referring to the plan administrator Consol. How do we know whether this award runs just against the plan administrator respondent, or whether the trustees thought the plan administrator and subsidiaries were one and the same?
Yeah, I believe that latter to be the case, and I believe the language is well chosen. This is a extraordinarily sophisticated panel.
It may be, this language seems extraordinarily not well chosen.
We think it runs to all parties, the respondents and the subs. If I can get back to Mr. Woodrum's argument here, he gave no reason why this valid arbitration award should be vacated. District court got this spot on. If you read the award, every assertion in it is backed up with reference to the record, submission, the preliminary injunction hearing. They considered the SPD plans, 120 pages of SPD plans that Consol submitted to them. They also considered whether the changes proposed by Consol, the administrator, would provide the same level of benefits. Ultimately, they decided that was not the case. So
that's a clarification question. after, now I'm going to go to the district court. Our court has remanded. The parties file a joint
Status report,
and they suggest dismissing counterclaims 1 and 2.
That's right.
But instead, the court grants summary judgment on counts 1 and 2, or judgment at least on count.
Yes, I think it was straight up just dismissal, Your Honor. There was no predicate summary judgment issue, and that's what the court's concerned about. We thought that if you read Judge, and I apologize for going, if you read Judge Nichols' September 30th decision, he makes two key decisions. Dispute was arbitrable, and it drew its essence from the contract. We thought that based on that decision, that issue of arbitrability was foreclosed, was conclusively established.
Apparently had granted you summary judgment on those counterclaims.
Yes,
as well.
and Mr. Woodrum's counsel on 1 and 2 were that basically the trustees lack the authority. And the arbitrability determination trumps those arguments. So
Maybe my question is more procedural than substantive, but it seems like you jointly suggested a resolution of the case.
right,
In particular, counts 1 and 2, and then you gave 2 options for counts, 2 or 3 options for counts 3 through 5. One was dismissing with prejudice, one was dismissing without prejudice, ripeness, lack of prosecution. Did Judge Nichols agree with your recommendations? Did he go his own way? What happened?
Judge, what happened was in Mr. Woodrum, in good faith, certainly the UMWA did, and of course Judge Nichols did. What we were trying to do, the court that was already remanded to them, and he said, gentlemen, give us some ideas here. And we thought that we would try to tailor the case as narrowly as we possibly could. And again, if there's a procedural defect in that, I apologize to the court on behalf of the union. And perhaps the best option is to remand to the judge for some clarification on the concerns raised by the court.
The best option would be to argue that there's nonetheless a final judgment, even if there was a procedural error, because it meets all of our cases that define what a final judgment is.
No, I understand, Judge.
We want to go back and do it again.
Absolutely, Judge. But these are not my concerns, they're the concerns of the court. And if they prevail after our argument today, perhaps that's the way. We think that we have a valid arbitration award. I think it imports entirely with the collective bargaining agreement, the trilogy progeny.
Okay.
And we also believe that we have standing.
Thank you.
Thank you. Thank you, Your Honor. Thank you.
Your arguments. Come step up to the microphone, sure.
I'd like to call the court's attention to what I think is very helpful on the question of finality. If the court would look at its own decision in the case of North American Butterfly Association v. Wolf. Judge Millett, I'm sure you're familiar with that case, being on the panel. 977 F. 3rd, 1244, 2020 case. In that case, which involved some of the similar kinds of issues, the court stated to decide whether an order dismissing without prejudice left nothing more for the district court to do, making it final, or instead signal the district court's expectation that the action would continue. And in this case, the order, we think, makes it very clear that Judge Nichols thought and intended that his order disposed of the case. He says, this is a final appealable order, and the clerk is directed to terminate the case. So on the finality question, we believe that's really effectively answered by this court's prior decision.
Right, with that, the case is submitted. We're going to take a 5-minute recess.
Please. This honorable court is again in session. Be seated, please. Case number 22-1320 et al. Absolute Healthcare doing business as Curaleaf, Arizona petitioner versus National Labor Relations Board. Mr. Dilger for the petitioner, Ms. Sheehy for the respondent.
Good afternoon, Your Honors. May it please the court. Jeffrey Dilger on behalf of Absolute Healthcare. This is a disparate treatment case in which there was no disparate treatment. The evidence in this case shows that the employer had a discipline process and that it followed that discipline process. And the evidence shows that it followed it for the alleged discriminatee in this case, Ms. Keene, and also for the comparator, Mr. Hubbard. In particular, Ms. Keene was subject prior to her termination, in which the board does not contest these levels were validly issued, 3 levels of progressive discipline for 11 violations of company policy. That included a final written warning, which by her own admission, you can find it at Joint Appendix 33, she admitted that the company told her another violation of policy would result in the termination of her employment.
Can I ask you a threshold question before we go too deep into what was briefed? My question for the board is going to be whether the NLRA protects a company, protects employees at a company if the company's core enterprise is illegal under federal law. So the question before that is your company's enterprise legal or illegal under federal law?
I know what the board will say. We are not contesting that there's jurisdiction under the National Labor Relations.
So my question is like a step before that. Is most of what you're selling illegal under federal law?
Under the Controlled Substances Act.
Okay,
Yes.
Then I'll ask her about the jurisdictional matters.
Of course, the Supreme Court has held the National Labor Relations Act provisions can apply to workers who are in the United States without documentation.
Right, it can.
Can I ask a separate question? And that is, you challenge the notice reading remedy here,
Yes.
but the General Counsel obtained an injunction early on, which was what reinstated Ms. Keene, but also included an obligation for a reading of the order, gather a meeting, read the order. So Ms. Cade was there, she signed the compliance order with the district court. So the notice reading requirement has already been fulfilled?
I would argue that it has, but the notice that has to be read will be slightly different than the court's order in the underlying 10J injunction. So I don't believe that it's been.
If your position it's already been complied with, then that would render that challenge moot. We'll see if the board says,
yeah,
you were supposed to read it twice or something, or.
I would argue that the purpose of the notice reading has been fulfilled in that any alleged violation.
I mean, like, it sounded like maybe you read the court's order, but the court's order was enforcing the board's order and it had all the same statements that were supposed to be read. Was there any material difference between what was read at that meeting and what the board's decision requires to be read?
Other than the reinstatement being interim versus fixed.
Right,
I'm not aware.
I had to say at that time.
But I also will admit that I have not compared the two recently.
Okay. Seems like there's a substantial question of mootness as to your notice reading claim.
Agreed.
I assume you're not saying that you have to do it twice.
I don't think that we should be required to do it
Nothing in
twice.
the board order requires you
Right.
to do it twice. And the general counsel that sought this initial reading requirement would be a little rich of them to turn around and say, no, you still have to do this other one.
I would agree. And I also believe that, like I said, the reading of the notice remedies any of the violations. It would be to do it again would make little sense. But I think,
Has there ever been a union election in the meantime? A lot of time has elapsed here.
no,
Is Ms. Keene still employed there?
Ms. Keene is employed on an interim basis pursuant to this
In the
proceeding.
position, right, okay.
And again, what I wanted to just make very clear with regards to her treatment in this case is that she was given a final written warning. She received 3 levels of progressive discipline before her ultimate infraction. But at the final written warning level, she was told, if you have another violation, it will result in the termination of your employment. And lo and behold, that's what happened. In late August and ultimately on August 28th, when the discharge was affected, she admitted that she had a $20 drawer shortage, that she had violated company policy. And so her termination was for precisely the reason that was proffered in the final written warning, another violation of company policy. And so it was valid. And you can compare.
I think that's your position, but it's not what the board found here. And they found, you're talking about what was the motive. And I understand your arguments. You've laid them out well in your brief. But they found that in fact, the motivation was her union activities. And you have, and so animus is, the existence of that is a factual question, correct?
So
It's a factual question?
well, it is a factual question,
That's
but
the animus question. What motive, when I say animus, that's my shorthand for what motivated the discharge.
yes.
And so we have a factual question. And given our standard review, it's not good enough for you to show it was more likely than not that you were going to discharge her, right? This isn't like a civil suit. We would essentially have to find that the board could not rationally, that it committed clear error in finding that the motivation was different than what you argue. And so that's not to dismiss the arguments you make in the record. It's just we're in a different world here where you're showing is, I mean, you've got a very steep hill to climb. So tell me how, given that Ms. Cade expressly disparaged her and her motivations in front of her coworkers, said to them, she's just in this for a paycheck, which is a way of saying she doesn't care about any of you co-employees, coworkers. Extraordinarily inappropriate comment and harmful and hurtful comment that suggests some real desire to hurt Ms. Keene. On top of the timing and the fact that there were other unfair labor violations all happening at this exact same time. Given that record, if we're given 2 stories here, both of which seem tenable, how, as a court, are we supposed to say that given that record, and for me particularly that disparagement on top of everything else, that it was irrational? No rational person could come to the conclusion that the board did.
So what I would just say is that the disparate treatment evidence actually weighs on both sides of the ledger here. There is both the prima facie case where the board is relying upon disparate treatment evidence to show animus. But then there is also the employer's rebuttal case where it is demonstrating that it would have done the same thing regardless of the prima facie case. And I think that that's where I would like to focus, which is that, and in particular, when you look at Mr. Hubbard, the comparator.
No, but so you've done enough. So we could say you did enough.
Yep.
To show that you had an argument on that side about your reasons for discharging her.
Yep.
Maybe even a good argument. Maybe it even seems more likely than not. But we can't decide the case on that basis. We have to say that you're showing essentially shut out any rational basis for concluding otherwise. And that's where I'm struggling. I hope you're going to help me given what evidence they had. And I think in particular, the direct targeted, a hostile disparagement of somebody in front of their coworkers, and not just disparaging her, but in a way that says she cares only about herself and none of you. That's a really horrible thing to say about somebody.
Well,
And so with that evidence, how could we say it was irrational to say that?
Because they're separate.
We think the scales tip towards animus.
Because they're separate burdens. Because that, you're talking about disparate treatment as it pertains to the animus.
I'm talking
the prima
about your
facie
job here,
case.
which is to overturn its ultimate conclusion. However the steps it went through, it made its showing, you responded. The board didn't say your response is invalid, we're not going to consider it. It said, thank you for your evidence. We are weighing the evidence on this record, and we've come to this factual conclusion. So it's not that you didn't present your case of you would have done it anyhow. It's that they had to make a factual judgment here, weighing the record, when there's a really powerful piece of evidence that seems to have animus written all over it.
But the comment does not bear upon whether there was disparate treatment, though. Because the disparate treatment, the evidence that the board relies upon, is the treatment of Mr. Hubbard. And when you look at the facts to facts, Mr. Hubbard also went through the discipline process. He also received a final written warning. And in that final written warning was told, if you have another violation, you will be terminated. And then he had a violation. He had the exact same violation.
I understand your story, but the board looks at it and goes, he had 7 cash store violations and she had 2 cash store violations.
This raises
I
the
know you're
next.
counting the other things, but they're saying, look, the cash store stuff, at least as to the cash store stuff,
But
you're much more flexible in your policy.
there's no basis for making that statement in the sense that this is a progressive discipline case. You can't simply say, we're just going to look at cash handling and ignore the other 10 violations. He was,
I'm sorry, through the stages of violation here, because I thought there was confusion whether he even ever had a first violation.
correct.
You let him, that your company let him pile up 3 or 4 of them before you even did the first.
Well, they skipped the verbal warning is what the evidence is. They moved to
They
written.
skip.
That actually would be more lenient towards Ms. Keene, not more lenient towards Mr. Hubbard as the board found him. Member Ring, I think, analyzes it correctly. In a progressive discipline case, when there's no basis and there's no explanation by the board, and this is the problem. This is a progressive discipline case, and yet the board ignores the totality of the progressive discipline. Hawaiian dredging holds that the board has to engage with the central factual issue, which is the entire circumstance in what she
Engaged with
was.
it here. I get you disagree with it. It definitely engaged with it. It said, that's not how your progressive discipline, as we look at the record, that's not how your progressive discipline program works. You have a lot of flexibility, and we see some flexibility in what you did with Mr. Hubbard. And so we have to ask, why didn't you do flexibility here? And that's when they bring in the animus problem. And
Again,
I understand your arguments that, we're not
Yeah.
deciding this is.
Well, again, I think that mixes the burden though, which is that disparate treatment is separate from animus. It is a separate, they're using it both on the prima facie case side, but also on the back end to try to rebut the employer's rebuttal case. And what we've shown, and again, I understand what you're saying, but what we've shown is that Mr. Hubbard was told, if you do it again, you're terminated. He did it again, he was terminated. And the same thing applied for Ms. Keene. So I would submit that the board's analysis with regards to the discharge is faulty for 3 reasons. 1, it's not supported by substantial evidence. 2, in accordance with Hawaiian dredging, they failed to assess the totality of the critical point where we were saying, you can't separate cash handling violations and just say, oh, that's all that she did. Because that's not why she was disciplined. It's not why she was discharged. She was discharged because she had 11 previous policy violations and 3 levels of discipline for that, which is more than the leeway that Mr. Hubbard was provided. And then upon violating her final written warning and the command, do not violate policy again, she did it. I don't know what an employer is supposed to do in this situation when it says, if you do it again, we're going to terminate you. And the board has no qualms with that. They say that was a lawfully issued discipline. And then she does it. And now suddenly we violate the act.
In the litany of violations with regard to Mr. Hubbard, I asked this question. Is a cash drawer discrepancy the same thing as a cash incident?
Yes.
So when I see March 5th cash incident, March 8th, $10 cash drawer discrepancy, that appears to be the same.
As I understand it, yes.
Later on, $10 drawer discrepancy, March 29, cash incident, March 30. Same one, same.
As I understand it.
Okay. There are three such double counts, it seems to me.
Sometimes on our standard of review, we talk about running directly counter to the evidence, and sometimes, many times, we talk about reviewing for substantial evidence. Do you have a sense of which of those we apply here?
I think that the standard is substantial evidence. The board's order has to be supported by substantial evidence.
Thank you very much. We'll give you a couple minutes for rebuttal.
All right. And on rebuttal, I'd like to talk about the union access issues.
Well, actually, then why don't we'll give you a minute now on that.
Okay.
So that they get a chance to respond.
Yeah, I would just like to say, so on both the notice reading and the access, the standard is severe, outrageous, or severe, pervasive, and outrageous. That's what the ULP has to be. We don't have that here. Even by the board's own admission in the board's order, it declares that these are severe violations. So there's that problem. In addition to that, the big question that I have is, how is the union access issue, and in particular the board's reasoning for it, that the company or that the union must be allowed to respond to future misinformation by the company? How is it not solved by the resolution of the 883 question? Either Ms. Keene goes back to work, and she's already been at work, she's been able to counter anything that the company would say, or of course that doesn't stand. And if the 883 doesn't stand, then there's no basis for the union access remedy.
When you say that you had a list of adjectives about how, the type of showing that's needed for union access, were those cases where access was accorded as a remedy for unfair labor practices, or whether it was sort of upfront access requirements?
Those are all access cases. And
I'm sorry, were any of them remedial cases?
They were all remedial union access cases.
Found an unfair labor violation.
Correct. And it's not surprising that almost all of those cases were in fact Gissel bargaining order cases. And we're not even close to Gissel bargaining order territory in this case.
Thank you very much.
Morning, Your Honors. May it please the court. Afternoon, I don't know, might be afternoon now, I'm not sure. Barbara Sheehy for the National Labor Relations Board. I'm going to start with Judge Walker's question about do you want to ask it, or do you want me to try to, is there a specific, other than what you asked my?
I guess I understand that plenty of lawful enterprises that do illegal things, sometimes very illegal things, the NLRA still applies to them. And as Judge Millett pointed out, it still applies to companies whose employees have been hired illegally. But here we have, I think, a criminal enterprise from top to bottom. Their raison d'etre is in complete violation of federal law. And it seems odd, maybe there's direct precedents that say this, but it seems odd if this enterprise was called like Hitmen Inc. If the board would issue an injunction that says like, you have to rehire this hitman, that would be a quite odd injunction for the federal government to order.
So I'm not sure I'm going to be able to give you a very satisfactory answer, partly because it hasn't been raised. The parties stipulated to it, so nobody talked about it. The board didn't speak to it, and I certainly don't want to speak on behalf of the board. For what as far as my understanding would go, it would be one of the first times they've spoken on a completely, as you said, illegal enterprise. But I would say it's possible, and I don't know, I'm not sure this is in the record, it's possible that it's not, depending on how it's structured, that it's not actually an illegal enterprise. So for instance, bear with me for 1 second. I think it is. I know, yeah. But I think in DC, for instance, they get around, I'm not sure it's been tested, but I think they get around some of the question about whether they're actually selling the product, selling marijuana, or whether you come in and you buy some sort of, I think it's like a t-shirt or something like that. And then as a gift, you get marijuana. So I do that, and I have no idea if that's how this dispensary is set up.
That can't be any more legal.
I don't think so. I don't think that's been tested.
Heroin as a gift?
I'm just suggesting it's that that companies have tried to structure it. The board has not spoken on this. And so I think this is just sort of begging the question that if this is a threshold matter of, well, first of all, we'd say it was 10-E'd, right? That it hasn't been raised by them. But if the court is inclined to say
that's they could raise and haven't raised.
Right. I'm sorry. Yeah. But if the court is saying, this is an ultra vires action outside the statute, whether they've raised it or not, I would say, please don't rely on anything that I'm saying on behalf of the board. Please send it back to the board in the first instance, for them to say something about whether they, like I said, starting off in a relatively unsatisfactory way. I'm going to move to Judge Millett's question about the mootness.
You're able to keep track of all this.
I'm just saying, it's been a long time since I was back here, so I was sort of excited. So as to the mootness, so again, I'd start with it wasn't raised by the employer, the substantial mootness.
Mootness is jurisdiction.
I'm sorry, right, but it hasn't been raised by them. So again, we didn't see briefing on it. We didn't see anything like this. I did look at the district court injunction, and I think opposing counsel, I think, is absolutely accurate. It is very, very close. I do think there is the question about the reinstatement part, about whether it's an interim reinstatement. And to the extent that there's any concern about it really truly is duplicative and moot, I think once the two, so I think the court could enforce. I think the court could enforce the notice reading remedy. And then if there is a question on the part of the employer saying, listen, this is too close. We've already done this. We've already complied.
Hang on, this notice reading was before the board ruled, correct?
Yes, that's the purpose of the 10J.
Were they aware that this had happened? I mean, it was a general counsel.
They would have to be, certainly.
They have to be aware.
Well, I mean, I assume they're aware because the board is the one that authorized the general counsel to go for the 10J.
So why wouldn't the problem be here why would the board nowhere addressed this? It issued a notice reading order when a notice reading had already happened. And, whatever one says about, whether notice readings are supposed to be extraordinary, how many actors you want to use, the board doesn't get to impose two.
No, but the board, let's be clear, the board did impose the first one. That was the district court. At the general counsel's request.
Authorized by the board?
The litigation is authorized by the board. Certainly, yes, the board authorizes the general counsel, but it's the district court that ordered that, not the board. So the
board should have grappled with that. I mean, I don't understand how the board can sort of have its cake and eat it too, and authorize the general counsel to go get an injunction. We can't wait for our decision to come out as the board. Go have her do this reading now, or stand there while someone else does the reading. And you're going to say, but we're going to leave a comma out. That's in our order. A pause, a word, an adjective might change. Of course, it's interim. The case, it has to be interim. We know what we're doing when we authorize these things. It has to be interim because they're still seeking a decision from the board. And then we're just going to impose another notice reading thing without saying boo about the fact that we already got, if not 100%, 99.9% of what we asked for. I don't understand why it's not an obligation on the board, fully aware of, to address it. Why isn't that an independent, obvious, public record on its face problem with the board decision here?
Right, and I completely understand the aggravation with what the board did, but I think taking a step back, I don't think it's fair to, so when I say I assume the board knows, that's because they authorized the injunction, but I don't know, for instance, if the board is following the actual general counsel's litigation. I mean, absolutely, it is.
General counsel doesn't have any obligation to update them.
I honestly don't know about who. Anyway, I don't know. I'm not sure.
We have to send it back to the board. Is there any?
Well, there's
any precedent for them doing it a second time?
So what I wanted to say that I didn't finish was that I'm not sure that it's fair. I honestly believe it was probably just an oversight on the part of the board that nobody raised it. The employer didn't say, wait a minute, we've already done this. Not to say that that's their fault, but as far as flagging it for them, and
they haven't raised it.
Right, no, and that so the board, either through oversight or what, but I don't think there was a nefarious purpose where they decided, listen, we're going to ask for it in the, and then we're going to order it there. That I truly think it was.
Remand, but you said we remand.
No, what I was going to say is I think what could happen is I think the court could enforce, because to the extent that
We're enforcing a second notice reading. We know a notice reading has already occurred and there's no dispute about it. And so what you're asking us to do is issue an order that would enforce notice reading number 2.
Right, but if there's a problem with this, so if the two notices are even slightly different, if the employer wants to say, we've already done this, they can argue that in compliance. It doesn't have to be a remand. They could go to compliance and say, we're not going to read the notice.
So the question is, who had the burden here? I mean, but you're asking us to say, there can be 2 notes. You can have to read it twice. You can have to read version A when it's interim, and then we're going to make you read version 2, B when it's no longer interim. And that's the only word that's going to change. There's nothing in this record that would give us any basis for concluding that that is appropriate, supported by the record, or even desired by the board. So it seems weird to me for us to go, oh, let's just go ahead and enforce it and make the employer come back and oppose it.
Right, and I guess I would say, I don't know exactly what the notice looks like. So I'm just really reluctant to say, just go ahead and don't enforce. It was good enough.
We have the text. If they were reading the district court's order, which seems insane to me, but that's what the general counsel seemingly asked for. It has all the, we can't do.
Right, but what I don't know is if there's any sort of like introductory remarks when that starts to say the district found that there was a likelihood that the board was going to prove that. And then they list, we did this, we won't do this. I think respect
of authorizing.
I'm sorry?
That's the risk of authorizing injunctive litigation on an issue.
No, but I think with all due respect, I think that that's a different notice if those introductory remarks, and I don't know if that's said. If that's not said, then I think I'm in.
If it is, then there's no base. I'm not aware of any case, board case or of ours, correct me if I'm wrong.
I'm not aware.
Where anyone's ever been told to do it twice. Do round A, preliminary one, and do round 2, final one.
Well, I don't know. That I'm not sure about, because we do have plenty of cases where there have been NJs that have issued and that have been notice readings. I know 2 of them that I've been involved with, for instance. And then there was enforcement, and there was a notice. There was a HTH, for instance, in this court. I know HTH.
Notice reading?
What's that?
There wasn't a second one.
I don't know. The district court ordered it. That was enforced. Whether there was compliance, I don't remember. But then the court ordered the notice reading in that. But again, you may be right. It may not have actually happened in the district court. But I know there was a 10J in that case, and there was a notice reading ordered, and it was ordered in court. Again, factually, I'm not sure, but it certainly wasn't discussed by the court. So it maybe just have sort of slipped through everybody's minds there. So I don't think. If that's what happened, I don't think this court was saying this is fine. So,
are these district court injunctions a somewhat new phenomenon, or has this been very common practice for a very long time?
The statutory provisions has existed. The 10J provision authorizing the general counsel to do this, or the board general counsel on its behalf, has existed forever, or since the act. But whether any particular general counsel, so it's up to the general counsel is the one who asks the board, can we go ahead and do this? So I think the frequency with which you see the board, general counsel, seeking these injunctions fluctuates depending on the priorities of particular general counsels. So I don't know if that answers your question. It's not a new phenomenon. We have an office dedicated to 10J injunctions. That's been around for a long time. That's not new. Like I said, the frequency fluctuates depending on priorities of particular general counsels.
Just to make crystal clear, your position is that their claim about notice reading is not moot, and you are asking us to enforce it.
I believe at this stage that's without seeing everything and understanding exactly what was read previously. I think I'd have to say that. Obviously subject to correction by this court. But no, that would be my position at this point. And then I just want to say 2 quick things. I see my time is over, but I'd like to say one thing or 2. So just very, very quickly, on the rebuttal case, I think it's very important to focus on would versus could. So I think opposing counsel said several times that they came forward and they showed we followed the discipline policy, and obviously the board disagrees that they rigidly adhered to that. So that we could have fired her. That is not the question. The employer had to show by a preponderance of the evidence that they would have done so. And I think there was also a statement that there was no information at all or nothing in the record to show that there was any drifting from the policy, and that's just not accurate. We put this in the brief, but I'm just going to say it one more time here. I think it's around Joint Appendix 109. There's the series of emails that starts right after she commits that August 22nd cash handling incident that prompted everything, that triggered her separation, where there is confusion among everybody involved with discipline. There's confusion from the HR director who is on site, or maybe not on site, but who oversees the Gilbert facility. That very person says, Anissa just had another this, cash handling. What do? There's a discussion then among supervisors and other district managers on how to treat that, where they say, it's cash handling, it's different, not sure. I think you could do this. So there's that evidence. There's Cook's statement that she says to Keene when they present her with the cash handling violation, and she says, I think it's 4. It's not a big deal. Again, not for truth of the matter, but certainly there's confusion on how cash handling incidents are treated.
This court said somewhat recently in Circus, right line second prong requires the board to examine first whether the employer reasonably believed the employee committed the acts supporting discipline. I take it that is not so much in dispute here. And second, whether the decision was consistent with the company's policies and practice. Do you dispute that the decision here was consistent with the company's policies and practice?
I would say that the decision was not consistent with its progressive discipline policy, unless you just say, we invoke that discretionary clause that's at the beginning of our policy all the time. So I think it's consistent with them exercising flexibility and not actually following the 4-step. So I'm not sure that answers the question. I don't think if we assume for the purposes of that question that the policy or that the practice that you're asking me about is they strictly adhere to a 4-step process before, and the 4th step being discharged, then absolutely not. I don't think it was consistent with that. If the question is the
practice, sorry, go ahead.
No. So, but if the question is, did they exercise flexibility with Hubbard consistent with the reserved discretion within the policy? I'd have to say yes. I don't think that they didn't, the board doesn't find that they went through as rigidly the steps, but the policy reserves to the employer the discretion to do that. So I'm not exactly sure how to answer that question. So they technically follow the policy, but not in the way that they claim they follow the policy.
Are we supposed to apply this test as Circus laid it out? Is that the right inquiry?
I'm sorry? I missed the last part about you.
Is that the right inquiry? Whether the decision was consistent with the company's policies and practices.
So I know that the employer sort of raises Circus maybe in like a footnote, and we say, they didn't raise that to the board. And what I'm a little confused on is in Circus, I don't know what it gets, because that's a good faith defense case as far as I understand it, that wasn't the employer's rebuttal case here as far as I understood it. So I think if you applied Circus, it doesn't change the results, because I don't think they have shown that any damage to the board's decision on the basis of that second part of Circus. I don't think that they were claiming a good faith defense. I don't think the board treated any of their rebuttal case as a good faith defense. Traditionally, a good faith defense is, I thought you actually did something wrong, so I terminated you. I terminated you for X, and I really had a good faith belief that you did X. It's not what happened here. So I'm a little confused actually on why Circus is sort of in the mix. And we were happy enough to just say, hey, you didn't raise it, so the board didn't address it. But then I understand they came back and said, well, we did raise it.
I guess I'm not sure I read Circus to require us. You distinguish between could have and would have. And I'm wondering if Circus requires the company here to show that it would have.
I guess then if that's the distinction, then that would be significant then. I guess I didn't understand that. So then if circus, if you confine that then to what is a good faith defense, that is very different than what they did here. Because traditionally under right line, what they've invoked the traditional defense, which is what we did was okay. We told you why we did it. It's not the way to go. She actually did it. And it was a legitimate reason for terminating her employment. And then the board imposes the obligation once the general counsel's met its burden, the board is going to impose an obligation on the employer to prove by preponderance of the evidence, fine, you've offered your legitimate reason. Now you have to show that you would have done it. So that's a different defense than under circus, which is the good faith basis, which I don't understand. I don't read any of their arguments either to the administrative law judge, to the board, or to here that there was any good faith. Nobody's disputing that she had that she was $20 short on her drawer on August 22nd. Nobody disputes that. They're not wrong. They're not wrong. So I don't think circus comes into play then as a good faith defense, because it's not that defense, if that makes sense. And then the last thing I will say, I promise I'm going to keep it under 30 seconds. It's just on the union access issue. I know Member Ring says this as well in his dissent, that there's no need for the union to be able to come in and speak to the employees because if she's back at work, everything is all set, everything's fixed. But I think that we don't have any idea if Anissa Keene, I know she's back interim, we don't know how long she's going to stay. There's evidence in the district court record that she actually was looking to go back to graduate school. But I think more importantly, that puts a huge onus on the person who stood up to organize for the union, suffered separation from the termination, to then just assume that that same person is going to go back and do the same thing again and start organizing and giving out all the information on the union, put her neck on the line again. I think that is not a reasonable view of Keene's responsibility. I don't think the remedy should be changed just because we think that Keene can take care of it. So, no further questions. We ask for full enforcement.
Very much.
Thank you.
We'll give you 2 minutes.
Obviously want to start right where it ended. The problem with this case is, I mean, you can look at the board's order at page 5. It orders it because the employer deprived its employees of access to accurate information about a union. I don't understand how the notice posting doesn't take care of that. We're talking about 381 statements, a threat, a promise, and an impression of surveillance. The notice.
Let's assume you're they're right on the discharge. So if you lose on that, then discharging the sole union organizer right at a critical time, and not just discharging her, trashing her reputation and name in front of all the employees, and then sending her out, they're just letting her come back in and posting a poster isn't going to fix the message from an employer. And that wasn't even the only unfair labor practice they engaged in, or else you're going to lose your tips, you're going to lose your benefits. We'll just tack up a poster here and everything's hunky-dory. That's just not realistic. This isn't, I take it, that big a workplace. And so it's really, as I read the board decision, we got to decide, we got to be fair to what the board decided, and that was that this is, you sort of struck a dagger at union organizing here. Maybe a couple of times you drove it into the heart, and so it's not enough just to tack up a poster.
So again, a single discharge does not sustain a union access remedy, and there's no case cited by the board where that's the case. But even beyond that, I think that the biggest problem that I have is, again, the board did not base it upon Anissa Keene's termination of employment.
They say discharging her, and we'll do the same to anyone else who tries to organize here.
So
a poster would be enough?
No.
One discharge?
One discharge it would not be enough.
Poster would not. So then they could do a union. Wait, let's just go down here. I'll give you a couple minutes to finish what you want to say. if you can have a union access remedy with one discharge, at least in the scenario I have posited.
I don't believe that you can.
I'm sorry, I misunderstood you. I thought you said that if they said we're firing her and on the way out, they said, and this same thing will happen to anyone else who tries to organize in this shop.
Well, I guess in that case, I think that it's possible.
So
But
we could have for one.
I think
So
that
it
it's,
really isn't a numbers game
if
here.
it's surrounded by other threats, and that is a hallmark violation in and of itself, right? The other 8A1 violations here aren't hallmark violations that are severe, pervasive, and outrageous. They're violations of the act, yes, but they're not severe, pervasive, and outrageous. If you compare the union access cases that the board cites,
Behavior was on the mindset of employees. We could debate all day how this was interpreted by the employees, but they sort of made the decision that on this record, a clear message was sent. Just as clear as if they said, we'll do the same thing to anybody else.
Well,
if that's what they found.
right, but that is not what the board found here. The board simply found that there were these this is a 53-day course of time. The 8A1, the 3 statements that were alleged to be unlawful all occurred in one 30-minute meeting.
Yeah, it's a pretty terrible meeting where she's disparaging Ms. Keene in front of her employees.
I encourage-
You can't, she's out to hurt you for her own self-interest.
I encourage you to review the cases that the board cites in support of the union access remedy, because those cases don't just involve one 30-minute meeting and determination a month plus later. They involve a consistent, truly severe, pervasive, where every day or every week there is a new violation. There is something new where the employer is expressing that it doesn't want the union, but that doesn't exist here.
Well, if the board finds that we need to impose a remedy that cures the violation. They said, this is what's needed. This is a small shop. And this was their first effort at union organizing. And so I don't, and we need it. We can't cure the problem. If that's what they find, we're going to say, sorry, you have to wait until the problem is 10 times worse. I get that you need that to cure it, but you just don't get to cure it.
But that's not what they say. They say that the
You need to
access
cure it because of the consequences, what the messaging is that comes when you discharge a
on,
union employee, and not just discharge, you drug her reputation through the mud.
no, respectfully, Your Honor, on page 5, the board offers its sole justification, which is that the employer deprived its opportunities of access to accurate information about a union.
We read it in the context of all the findings that they've made. We don't just pick one sentence out at a time and look at it. It's not how we read agency decisions.
Well, fair, but under this court's precedent, the board has to explain why the extraordinary remedies are necessary. And the sole explanation that it gives is that there was misinformation and it had to be corrected. Well, the posting and frankly, the notice reading from the district court resolves anything that was said previously. And so this remedy that they're seeking, the reason that they're seeking it is based upon some future unknown conduct that maybe the company will again violate the law, but that can't be the basis for a union access remedy.
On the same question, I'll ask you the same thing. So do you think your notice reading claim is moot? You've satisfied it? You can't be required to do it again, or do you agree that the way for us to deal with that would be to, assuming we agree with the board on its other claims, that to enforce the board's order and let you fight it out on remand in the compliance stage?
I think that it's mooted, and if it's not mooted in fact, it's mooted in practice, in the sense that the message has already been sent to the employees. And so what is the point of sending it again? And even in this case, if the board affirms the order, or even in part, there will be a notice posting that is again issued in this case. And so there will be a remedy. It is not as though the court makes its decision and nothing happened.
Mr. Dilger, a moment ago, you said that all the prior access cases involved a series of significant violations.
Yes.
Did you also say earlier on that they were all 8A3 cases?
There are, I believe, 1 or 2 that don't involve 8A3s, but they involve hallmark violations, threats of plant closure, threats of job loss, things of that nature.
Okay.
They're serious. And then there's this other culture where the board finds that the employer has some serious goal to constantly go at the employees and destroy the union. And I submit that
When you
doesn't.
referred to Gissel, though, saying this is nowhere near a Gissel case, I took that to mean that all the others were.
I believe that the other access cases that are cited, well, Stern Produce was a Gissel case. United Dairy Farmers Cooperation, oddly enough, was a case that was so severe that the board contemplated issuing a non-majority bargaining order. I mean, that's the level of conduct.
They were 8A5s.
There were 8A3s, I believe, in both of the, in the United Dairy case. I don't recall if there was in the Stern case. I know that there were 8A5s or 8A3s in the United Dairy.
Thank you.
Thank you very much. The case is submitted.
Honorable